Here to talk about the Adelson case. Um, Days number 7, 8, and 9. With that being said, let's get into it.
When your laundry chair is giving mouth wash more just before Parents' Weekend, you can just ask Google for solutions nearby. There, that looks close. Ooh, smells better in here too.
And landing in Denver for CrimeCon. So I hope to see many of you there. Come up, say hi to me. I will not have a booth, but I will be.
I will be going through day 7, day 8, and day 9, all in this recording. Thank you.
There participating in a few things, and I will have some freebies for all of you, from pins to some fly swatters from Ed McGee, the Day One case, a few other goodies. So I hope to see many of you there and meet you in person. And also, there is, excuse me, there is a new docuseries out. First two episodes dropped last night or yesterday, September 1st. Ruby and Jody, The Cult of Sin and Influence. It's the third documentary, or not documentary, it's the second documentary on this, the third sort of main show about this case, the Ruby Frankie Jody Hildebrand case. And I am in that one. I was also in the one about the Curious case of Jody Hildebrand, so check that out. Anyway, hello everyone, and as always, forgive my little cough. You know, it always gets worse when I'm traveling. Things are going really, really, really well with my little cough, and then something jinxes me. And it's been stressful, and I've been traveling, and so forgive me. We'll try to keep this under control. It's just a little spasm in my throat, actually. I'm good. I'm feeling good. So thank you, everyone, for bearing with me. The other downside, hold on. The other downside with the travel set is my mute button isn't so easy to grab. So, anyway, so no more apologies. Let's just get to today, because today marks day 7 of the Donna Adelson trial. And again, first day of defense, the family matriarch accused of conspiring to have her ex-son-in-law, Dan Markell, murdered. And on Friday, again, the state rested its case. So today begins testimony from the defense's witness list. And after we recap what happened in court today, stay tuned into
Be
the
right
end,
back in a
where I will
second.
share actually some very interesting information I recently learned about Donna's lead defense attorney, Jackie Fulford. So stay tuned. There you go. Day 7 began with the defense filing a motion for acquittal, something that's common in trials like this, even though it rarely succeeds. The defense argued that Donna never incited, encouraged, or assisted in the plan to kill him. So, there you go. Of course, they do. They emphasized the men who carried out the murder, Sigfredo Garcia and Luis Rivera, were allegedly hired through Catherine Frank Manawa, not Donna. They argued that the chain of communication ran through Charlie, not Donna. They also pointed out that Charlie, not Donna, was the one who had large amounts of stable cash in a safe, and that there was no evidence Donna ever had control of it. The defense stressed that there's no proof Donna knew about Wendy's comment to her boyfriend, Jeff, when she said the only way she could leave Tallahassee was if something happened to Dan. They also said there's no evidence that Donna was aware of Charlie's talking about hiring a hitman back in 2013 after Wendy's location request was denied. According to them, all the jury has heard are assumptions and theories, not direct evidence of Donna's involvement. They argued that Donna's actions after the murder, like following Wendy's instructions on which last names to call her sons, don't prove she intended for Dan's death beforehand. They also said that payments made to Catherine after the fact also don't prove premeditation. The defense downplayed Donna's emails and the so-called birthday gift saying that her last hostile message about Anne was in 2013, and that the gift was simply part of a party for Harvey at a venue called the K-Room, not a coded reference to murder. And in closing, the defense leaned on legal precedent that argues that conspiracy alone isn't enough to convict. Her suspicious behavior after the murder did not prove intent or involvement on July 18, 2014, the day Dan was killed. Their bottom line was clear. Inferences aren't evidence. After the defense argued for acquittal, the prosecution pushed back hard, telling the court there is more than enough evidence for the case to go forward. The state pointed to Donna's own emails, which they say revealed her hatred of Dan and a clear motive. With him gone, Wendy and the grandchildren could relocate to Miami. Out of everyone, Donna stood to benefit the most. And the state reminded the jury of Luis Rivera's testimony that he and Secreto
Okay, I'm
surveilled
back, y'all.
Dan before the murder. They tied this to Donna's 2014 planner, which contained Dan's car detail and his license plate number, which the state argued was a direct link to the surveillance. They also cited Catherine, who said Charlie told her that his mom had washed the money that was given to the killers. Phone records in Donna's 1-hour gap driving toward Tallahassee on the night of the murder were presented as corroboration that she was at Charlie's house. The state also leaned on family testimony. Donna's oldest son, Rob, told jurors that she instructed him not to speak to the FBI. And when he admitted that he had, she brushed it off by saying, quote, well, you don't know anything anyway, unquote. The state cast this instruction as deliberate avoidance, which they argued points to guilt. Financial evidence was another focus. The state said Donna maintained large cash reserves and directly shared money with Charlie. So over 2 years, she personally signed 44 checks to Catherine, even though Charlie could have signed them himself, being the owner of the business. Prosecutors framed this as Donna's direct funding of the murder plot. They also highlighted the undercover bomb video. After seeing an article about the case with Dan's picture, Donna immediately called Charlie and said, quote, this involves the two of us, end quote. The state labeled this as a direct admission of guilt. 2 inmates, Patricia Bird and Drina Bernhardt, also testified that Donna admitted her involvement and tried to bribe them with things in exchange for false testimony. Bernhardt said Donna went so far as to write her a script to study and recite in court. Finally, the state pointed to Donna's shifting defense. In 2016, she spoke casually about Catherine. Why was it Charlie's prior year that she adopted this extortion theory? And just hours after Charlie was convicted, Donna texted Wendy, quote, I'm next. But that won't happen. I'll take care of that, end quote. She then scrambled to obtain an emergency visa for Vietnam, a country with no extradition treaty. To the state, this wasn't coincidence, it was consciousness of guilt. So after hearing both sides, Judge Everett ruled that when the evidence is viewed in the light most favorable to the state, both the circumstantial and direct evidence presented are sufficient to move forward. With that, Judge Everett denied the defense's motion for judgment of acquittal on counts 1 and 3. And the defense then called their first witness, Anne Cunningham. And Anne, I'm going to take a sip of water. Let's talk about Anne. Anne Cunningham. Let's get to Anne Cunningham. So Anne has known Donna for a very long time and has known Donna since 2009. Anne explained that on Christmas Eve of that year, her husband Ronald cracked a tooth during dinner. And because Ronald had gone to high school with Harvey, he reached out, and Harvey came into the office on Christmas Day to treat him. And that visit led the two men to reconnect, old high school friends, and soon after they arranged a dinner with their wives. That was the night Anne first met Donna, and from there the couples formed a close friendship. They began spending significant significant time together, traveling often and speaking regularly by phone. Anne testified that she eventually met two of Donna and Harvey's children, Wendy and Charlie, as well as Wendy's husband at the time, Dan Markel, the victim in this case, as well as Wendy and Dan Markel's children. So next, pull this a little forward. Oh, there goes my travel issues, microphone. Okay, we're good? No? Okay. We're good? Okay. We're good. Hey everyone, still here. We're good. So, next, defense attorney Fulford asked Anne if, over the years, she had known Donna, he ever found her to be a hateful person while knowing her, and Anne's answer, no. She said Donna was never aggressive towards anyone, never threatened anyone, never harmed anyone, and never threatened to have anyone harmed. If Fulford then asked if, from the time when they began the divorce up until Dan's murder, if Donna had ever said she wanted Dan killed, Anne again said no. She explained that Donna did get upset and vented about the situation when he was with Dan, but never in a threatening way. She described Donna as very supportive of her children. Anne also testified that, like the Adelsons and the Markels, she is Jewish, and that she found Donna's way of raising her children to be consistent with Jewish traditions. Anne recalled that Donna called her the day that Dan Markel was shot and said she sounded extremely upset. Donna was crying, appeared surprised, and said she had just learned what happened. Donna told her that she and Harvey were on their way to be with Wendy and the boys because they were scared for their safety since they didn't know who had shot Dan. Anne added that Donna was very concerned about Dan being in the hospital. Later, Donna told Anne about Dan's memorial service, describing it as incredibly sad and heart-wrenching. Eventually, Anne became aware that Charlie had been arrested, but she explained that she didn't keep up with the case on social media and tried not to watch much of the news coverage during Charlie's trial. She and her husband allowed Harvey and Donna to stay at their home in Naples, where they could watch the trial. After the guilty verdict, Anne asked Donna what she was going to do, and she said that Donna was extremely upset at the time, cried a lot, and was deeply concerned about both Harvey and Charlie. According to Anne, Donna was incredibly sad and seemed to be weighing her options for how to cope, including at one point taking her own life. She also mentioned the idea of just getting away for a while to clear her head. So Fulford then asked Anne if she knew about Wendy's youngest child's upcoming bar mitzvah in January 2024. And Anne said yes, and that she actually attended Donna's grandchild's bar mitzvah, Wendy and Dan's youngest child's bar mitzvah, and she explained that as a Jewish mother and grandmother, those traditions are very important, and based on her relationship with Donna, she believed Donna would never miss it. She said Donna had fully intended to be there and was very excited about it. On cross-examination, Prosecutor Kappelman asked Anne if she was familiar with the statement Donna made to Wendy, that she could just bury her in the dress she bought for the bar mitzvah. Take a listen.
Are you familiar with the defendant's statement that she could be buried in the bar mitzvah dress that she bought?
No, I'm not.
Because if she's going to be buried in that dress, she probably wasn't, at least at the time she made that statement, going to be making it to the bar mitzvah, would you agree?
No, she's always going to be making it to the bar mitzvah, as far as I know.
Even if she was dead and buried, she was going to make it.
I never heard that.
Was she suicidal when you spoke with her? After Charlie's verdict?
Yes.
You were best friends with her.
Yes.
And she would call and vent to you about Danny Markel.
Sometimes.
And did she ever call him names?
Not to my knowledge, not to me.
Did she share with you that she was planning to offer a bribe to Mr. Markel to facilitate
I
relocation?
don't recall.
Did she talk to you about plans to threaten or to convert children to Christianity in order to strong on Mr. Markel?
She mentioned that she had said that, and she said that was so foolish of me.
When did she say that?
I don't know whether we were together or on a phone call, I'm not sure.
Next, Kappelman asked Anne if Donna had ever told her that she was being extorted in connection with Dan's murder. Anne said that Donna did eventually tell her, but although she couldn't recall exactly when, only that it came up while they were on a trip to Japan. Kappelman pressed pressed her on whether this was before or after the FBI's undercover bump, and whether Donna's writing of checks to Catherine was part of that extortion, but Anne said she wasn't sure. Catwoman then turned to the night of Charlie's verdict, asking if that was when Donna called Anne and said she was worried and was considering self-harm. Anne confirmed it was, so Catwoman asked her to provide her phone number, seeking to verify the call. Anne added that she hadn't followed Charlie's trial closely until the very end, and during the proceedings she and Donna did not discuss it much. Catwoman then handed Anne her text messages with Donna to review, and after the verdict, the two exchanged messages where Anne said she disagreed with the outcome and thought the jury got it wrong. When asked if that was out of loyalty to her friend, Anne said no, she genuinely believed the jury made a mistake. In one message, she wrote, quote, "I know you are all in caps, all innocent," end quote. So with that all in capital letters clarifying in court that she meant Charlie, Wendy, Donna, Harvey, and testified that she believes no Adelson had anything to do with Dan's murder. Catwoman also asked if Donna had simply chosen to clear her head in a non-extradition country, and said she wasn't aware Vietnam was non-extradition. Georgia Press say, quote, "She was going to clear her head with a one-way ticket?" And Anne replied that Donna and Harvey didn't know how long they would be staying or where they might travel afterward. Finally, Catwoman asked if Donna had ever told Anne she hoped to make it to the airport before law enforcement could catch her, but Anne said she didn't recall. Catwoman then had Anne review some text messages between her and Donna, in which Donna described Harvey as lying on the floor, crying like a baby after Charlie's verdict, and mentioned that Wendy hadn't even called them. Anne testified that she'd offered to come be with them for comfort after that. On redirect, Fulford had Anne clarify that at the time Donna was said to be writing checks to Catherine, Donna never told her about any of that. When Donna spoke about extortion, she said that Charlie was being extorted. Donna never said that she was personally being extorted. Fulford then addressed the state's implication that Donna was choosing to travel to a non-extradition country with the plan to not return. Anne clarified that Donna never said she wasn't going to return, and, in fact, had said she was definitely coming back for her grandson's bar mitzvah. Up next on the stand was Ron Gunnarsson, Anne's husband, who knew Harvey all the way back to high school and reconnected with him after that Christmas tooth incident. In 2009, Harvey saved the day in high school and reconnected with him after that Christmas tooth incident in 2009 when Harvey saved the day.
Again, y'all, this is day 7.
Developing a close relationship between the couples. He described Donna and Harvey's relationship as very loving, warm, and close. And like Anne, Ron became aware that Charlie had been arrested during the investigation into Dan's murder. During Charlie's trial, he testified that Harvey and Donna's state of mind was extremely upset. Off the wall, quote, as he put it, which he explained was natural for loving and caring parents. Ron said he and Anne allowed Donna and Harvey to stay at their Naples home during the trial because they were being harassed by the media and bloggers at their own house. Their gated community provided additional security during that time. After the verdict, Ron said Anne spoke with Donna, and both she and Harvey were extremely distraught, with Harvey being, quote, off the wall, devastated. Ron testified that he was aware Harvey and Donna planned to travel temporarily to clear their heads from November to January with the clear intention of returning for their grandson's bar mitzvah. He emphasized that under normal circumstances, they would have moved heaven and earth. Next, defense attorney Bowman asked if, while Donna and Harvey were traveling, Ron had been asked to assist with their rental property business. Ron explained that if their handyman needed approval to purchase anything for the properties, like a new AC or appliance, he would approve it while Harvey and Donna were away. He emphasized that this was only a temporary arrangement until their return. Across examination, Catwoman focused on Ron's statement that, under, quote, normal circumstances, Donna and Harvey would have moved to heaven and earth to attend the bar mitzvah. And she said, quote, obviously, normal circumstances would not include a warrant being issued for their arrest for first-degree murder. That would be abnormal circumstance, end quote. So Ron replied that he wasn't aware of any warrant at the time of their travel plans, and there was none they knew of. Appleman suggested that such a warrant might cause them not to return, and Ron responded, "You might have to think twice." End quote.
Sounds like a
Appleman
threat.
brought up a text Donna sent to Ron and Ann that said, quote, "Can't say exactly why, but we may need you guys to come here soon." End quote. Ron confirmed that this was simply for moral support. Donna also wrote,
Was it?
quote, "Wendy isn't responding, so we may have some issues we may need your help with," end quote. Ron explained that this was in regard to needing assistance with the rental properties and as friends to help out, adding, "That's what friends are for." Next, the defense called digital forensic expert Kelsey Way, a senior digital forensic examiner with roll-off digital forensics in Spokane, Washington. She introduced herself to the jury and detailed her background in digital forensics, including a 2016 master's degree in criminal justice, experience with the Clackamas County Sheriff's Office in Portland Police Bureau, and later managing a digital forensics lab. She specializes in call center records, cyber and internet crimes, and device instructions. Boyd testified that she has reviewed close to 1,000 call detail record sets mapping for many cell site locations and has completed over 400 hours of digital forensic training. Boyd explained that her analysis focused on Donna's AT&T phone record, but she also reviewed Sprint, Verizon, and T-Mobile data as well. She explained documents spanning from January 1st, 2014 through May 2017 because they included seconds into the timestamps, allowing precise chronological reconstruction. She reviewed Sergeant Corbett's 350-page slide PowerPoint, focusing on slides 26 and 28, which contained frequency analysis charts, finding the raw data messy. Boy exported it. There's a lot of extortion going on in this case, but Boy exported it to Excel rather than relying solely on PowerPoint tools. She emphasized the importance of seconds and accurate UTC to Eastern Time conversions for reliable analysis, and testified that she manually reviewed Donna's call records. For example, she found that instead of 80 contacts between Donna and Charlie in June and July 2014, the real number was 69, noting that law enforcement's failure to deduplicate calls had inflated totals. Regarding July 18th, 2014, Boyd testified that Donna's phone never connected to a tower that could cover Charlie's residence.
Give me 1
There was
second.
no overlap with Charlie's handset on any tower that day. Prosecutor Sarah Dugan then cross-examined Guay and pressed on both her methodology and conclusions. Dugan noted that Donna's phone pinged in North Miami at 8:35 p.m. and next at 10:57 p.m. north of Charlie's residence. Dugan also pointed out that no record exists for Donna being outside Charlie's house, and that notation only appeared in Donna's iMessages, not in tower data. Dugan asked Guay if there was a call between Donna and Ann Cunningham the night of July 18, 2014. Guay said she didn't know from memory and was asked to check the raw records on her laptop. After checking, she said that she didn't see a call from Donna to Ann's phone number, but it's possible she called another day, as Ron said during his testimony. Guay also clarified that Sergeant Corbett's charts.
I hope everyone can hear me. I just cut my mic on. Can you hear me? Put one in the comments if you can hear me on the playback. Thank you.
Did reflect the raw records, but just failed to remove duplicate calls. After recalculating, she found fewer actual calls, 69 versus 80, between Donna and Charlie in the key weeks before the murder. She clarified, however, that duplicates in the records don't erase the fact that Charlie was still Donna's top contact. Even with 69 calls instead of 80, the pattern remains the same. No change to the pattern. And the jury
That's weird.
learned that Guay earns $300 per hour and had earned
Okay,
about
we're back.
$10,000 for her work on this case. I think something the jury should always know. On redirect, the defense at Guay clarified that Donna's record showed 211 unique calls with Charlie, not 417. She emphasized that call detail records do not capture communications via apps like WhatsApp or
Trying
Line.
working
And on
right.
July 18th, Donna's phone was in constant data sessions, which was consistent with the possibility that she was communicating with Andy
Hold on.
through an app like Viber or WhatsApp, and not just text. Nothing unusual occurred after lunch recess, and Cunningham was brought back to the stand. It's always interesting when they bring a witness back to the stand. She was brought back to the stand to clarify something from her previous testimony. And Fulford asked her which two apps, in addition to her regular phone service, did she use to communicate with people, and she said she uses WhatsApp and Viber. Fulford asked if she routinely used one of those apps to communicate with Donna, and Anne said yes. They routinely used WhatsApp or Viber to talk to each other. Let's listen to Kappelman ask her about this, because it's clear she finds Anne's testimony about using these apps a little fishy. Take a listen.
You had gone to the airport after your last testimony, right?
That is correct.
And returned to the courthouse?
Yes.
To tell us what, that you used Viber or WhatsApp to make
Yes.
that phone call?
Yes.
So it wasn't a regular phone call?
Correct.
Okay, so you misspoke earlier, or it just wasn't clear?
No, it says she called me.
Okay, and she called you and made a regular phone call on June 23rd, the month before the murder, right?
I don't recall many. She made many phone calls.
She called you on a regular line on July 20th. On that.
She said so.
Okay, and July 21st.
Yeah, the witness is not returning the evidence.
Okay, here we go.
She was not
Isn't
asked,
that?
or she was not asked to recall or, let me clear this up. It's Cunningham. You need to see the item that the state is referring to refresh your recollection.
Do I? Yes, if I called her, if I spoke with her, I spoke with her.
Okay, so you have no reason to contest that you spoke with her via regular phone call, June 23rd, July 20th, and July 21st.
If it's on the record, yes.
But you're saying it was a WhatsApp or a Viber on the 18th.
Yes, they were in the car, and they often called on those apps in the car.
Would it surprise you to learn that WhatsApp didn't offer voice calls until March of 2015?
Then it was on Viber.
Must have been Viber, huh?
Must have been Viber. Up next on the stand was Richard Chagrin. He explained that he met the Adelsons about 37 years ago through a friend's nonprofit where he was serving as chairman at the time. Later, he and his wife formed a gourmet club, which Donna and Harvey joined, and over time they all became close friends, spending more time together and traveling. Richard noted that his wife is a real estate corporate and bankruptcy attorney. Defense attorney Zalman asked if Richard spoke with the Adelsons the day Charlie was convicted. He said no, it was the next day that he and his wife went to the Adelsons' residence in Miami. He described Donna as extremely distraught and Harvey as being in shock. Richard explained he is very experienced with booking trips and travel, having visited 75 different countries, and that the Adelsons asked for his assistance in November 2023 to help obtain visas for Vietnam. And while Donna showed his wife Susan the dress she had bought for their grandson's bar mitzvah, he and Harvey sat down to book plane reservations. Richard noticed that a round-trip ticket was much more expensive than a one-way ticket. Since they didn't know where and when they would return, he advised booking a one-way ticket and mentioned to Harvey that it would likely be cheaper to buy a flight home from Vietnam once they were already there. In regard to the visas, Richard explained that there were only two options, a 30-day or a 90-day visa. He chose the 90-day visa for the Adelsons because they didn't know how long they would be gone, only that they intended to return before their grandson's bar mitzvah in January. Zellman then asked Richard if he knew why the Adelsons wanted to leave town, and he said they were being berated by the media, afraid to leave their condo, and simply wanted to get away for a while. Richard also noted that Donna and Harvey had visited Vietnam with him in the past and found it very relaxing, with great people, excellent food. Richard added that although Harvey technically booked the flight, he was sitting next to him, helping him choose, and advised that it made more sense to book a one-way ticket. He emphasized that they were all operating under the assumption and per their attorney's instructions that they were free to travel without any restrictions. Next, Zellman asked Richard to describe the type of mother and grandmother Donna was. And he said she was the ultimate Jewish mother, very involved in her children and grandchildren's lives, and did everything she could for them. Zellman then clarified, asking if at the time he was assisting with booking their travel, the Adelsons had decided when they were going to return. Richard said they were undecided, other than being certain they would not miss their grandson's bar mitzvah. On cross-examination, Kappelman asked Richard if, when they booked the trip, the bar mitzvah was less than 90 days away, and Richard said yes, it was scheduled for January. She then asked if he recalled giving a deposition in August 2024, and he said vaguely, during that deposition, Kappelman noted that he had been asked whether he made any decisions about when or how the Adelsons should travel, or if he was merely a conduit for the technology. At the time, Richard acknowledged he had just been there for him, and Kappelman pressed, saying, quote, "But today you're saying you're the one who suggested they only buy a one-way ticket." And the defense objected, claiming improper impeachment, but the objection was quickly overruled. Richard responded that making suggestions didn't mean he was making the travel decisions for them. Kappelman then moved on to this more hot-button issue. Just take a listen to this. Let's watch this
And you
together.
said that Donna Adelson is a typical Jewish grandmother. Does a typical Jewish grandmother suggest dressing her grandchildren up in Nazi uniforms?
Not to my knowledge.
No further questions.
Yeah, there you go. That was an interesting moment. So, on redirect, Zellman asked Richard again if, in addition to being tech savvy, he was more travel savvy than Donna and Harvey, and he said yes. Zellman then asked if, during his deposition, Kappelman had asked him whether he had made any suggestions regarding their travel while helping them book flights. Richard said no. And next on the stand was Eddie Varnes, a private investigator with 27 years of experience, and he was retained by Donna's original defense attorneys and tasked with speaking to Patricia Bird, one of the jailhouse snitches. Varnes introduced himself to Bird, saying he understood she might have information about Donna's case, and she confirmed she did. Bird told him she had information about things Catherine McBanois had said to her while they were incarcerated together in 2021. She never told Varnes that Donna offered her any compensation to testify, nor did she mention anything about land, a trailer, a car, veneers, or any other offer from Donna. Bird also never said that Donna confessed to her. Varnes testified that he did not record the interview with Bird, as he had been instructed by prior defense counsel not to. Okay? He explained that Bird spoke extensively about Catherine, but never about Donna, telling her to say anything. Varnes said he cautioned Bird against cooperating with Donna, warning that she would be a witness in the case and that the state might suggest she was given something by Donna to falsely testify. And Bird reportedly replied, quote, "They can say all they want, but this is the truth," end quote. Varnes added that he was aware Bird was waiting for a plea deal in her own case at the time he spoke with her about Donna. And on cross-examination, Dugan asked Varnes if he decided to question Bird because Donna's previous defense counsel told him she might have information, noting that this was prior to July 2025 when she was officially listed as a witness by the state. Dugan brought up that Varnes didn't record the interview, even though he technically could have, and Varnes said he had been instructed not to. Dugan then asked Varnes to relay what Bird had told him during the interview. Varnes testified that Bird said Catherine told her, quote, "After we had him killed, we tried to get the money because we knew her boyfriend and family had a lot of money. We knew they had money because the family offered the man $1 million apiece to move to South Florida, so why not kill him and get the money ourselves," end quote. And Bird reportedly responded, quote, "Girl, that's crazy, that's extortion." And Catherine said, quote, "My kids got to be raised and go to college as well." Quote. Warren said he sent a summary report of the conversation to Donna's legal team, but they didn't instruct him to go back again to record her statement for evidence. Dugan then asked if Barnes knew why Donna's defense didn't list Bird as a witness, despite this information, and he said he did not, noting that he is not an attorney. On redirect, Zellman had Barnes reiterate that what he related was exactly what Bird said during the interview, not just his own interpretation. Zellman then asked about why Bird was not placed on the defense witness list. Let's take a look at that.
Would it surprise you, sir, to learn that contrary to what the state implied?
Relatives asking what he was surprised by.
Please let him finish his question first. Judge.
Thank you, Your Honor. Would it surprise you to learn that the prior defense counsel in fact listed Patricia Bird on the witness list that they submitted prior to this case being set for trial in September of 2024?
Would that surprise me? No.
And so, contrary to what Ms. Dugan indicated on cross-examination, it was your understanding that Ms. Bird was listed as a defense witness.
Yes, sir, that is correct.
Just a moment, Your Honor.
Up next was Leon County Deputy Josh Turner. He testified that he interviewed the other jailhouse snitch, Drina Bernhardt, on December 18th, 2024. And after that interview, he noted that to the state's attorney's office that Drina had information pertaining to Donna Adelson. Turner attended a recorded interview with Drina at the state attorney's office. During that interview, Drina said she had spoken to Donna throughout the day and had purposely positioned herself in front of a camera in the pod so that the interactions would be captured on surveillance footage. State's Exhibit 105 was a recording from within the pod, which Turner reviewed for court, and after the interview at the state attorney's office, Turner downloaded the surveillance video. And Drina and Donna are on the far right of the screen at the round table. Take a look at this.
Okay.
Explain to the jury what Ms. Bernhardt just did.
It appears she took a piece of paper out of her notebook, and it's showing Miss Adelson something on that page.
Appears that something's already written on that page.
Potentially, I can't tell.
Now, Ms. Bernhardt's writing on the piece of paper.
Correct. Yes.
1446. My client takes paper and starts writing, correct?
Correct.
So we can see both women writing on the paper, but when asked if Donna dictated and Drina wrote, Drina testified no, Donna wrote. However, Drina could be seen writing on papers and talking to Donna as she wrote some things, which could suggest that Drina was dictating to Donna what to write, or at least cast some doubt on Drina's story. Well, on cross-examination, Kappelman noted that during his interview with Drina, she said she not only had information about Donna, but also that Donna was trying to solicit her to give perjured testimony during the trial. Turner testified that he relayed this to the state's attorney's office, where a more detailed interview with Drina was conducted, and in that interview, Drina brought a pink notebook containing the script Donna allegedly wrote for her to recite at trial. Turner explained that they had to photograph the notebook rather than seize it because Donna had allegedly instructed Drina to copy the script in her own handwriting and then return the notebook. Kappelman asked if Drina said when the original script was written by Donna, and Turner said she indicated December 19th, the video of which he had downloaded and was just played in court. Kappelman then asked if the video appeared to corroborate what Drina told investigators that day, and Turner said it did. Kappelman pointed out that the defense argued both women could be seen writing in the notebook, but Turner said he wasn't sure if both actually wrote the script and deferred to a handwriting expert's testimony. He noted that the handwriting expert had concluded that the script was in Donna's handwriting. Interesting place, right? I was like waiting for more at that moment, but that's where court ended for the day. A little earlier than usual. So we'll have to wait. I'll be back tomorrow. But as I promised, I have some interesting information to give you regarding Donna's defense attorney, Jackie Fulford. Now, I had heard rumors that Fulford was an ex-judge, but what I hadn't heard is that actually she's possibly a disgraced ex-judge. So, Jackie Fulford was once a respected prosecutor and later became a circuit court judge after being appointed in 2009 by the governor. She oversaw the Second Judicial Circuit, which encompasses Tallahassee and nearby areas. However, her judicial career faced serious challenges in 2015 when the Florida Judicial Qualifications Commission filed a formal misconduct allegation against her. Now, these allegations, these charges, what they included were abuse of office, conflicts of interest, coercion, and using her judicial authority to benefit her personal interests. So one notable controversy arose during the 2012 sheriff's election. Fulford openly supported the incumbent and personal friend David Harvey, even displaying a life-size cardboard cutout of him in her office. While judges, they're allowed to have political opinions, problems emerged though when a courtroom bailiff supported Harvey's opponent. And Fulford allegedly told the bailiff she would not work with anyone who backed the opposition, and the bailiff was subsequently terminated. Well, allegations of coercion also surfaced in one case. Fulford was overseeing a matter in which a defense attorney had a major motion pending, and during this time she allegedly asked the attorney for a personal favor, which was to represent someone she knew in an unrelated case pro bono. So the attorney reportedly
that is a conflict of interest.
Influence over the outcome of his client's case, which carried a potential 15-year sentence. So critics argued that she exploited her position to secure a personal benefit.
She did.
So Fulford's involvement in her partner's family matters further complicated her record. So in 2013, her partner's son, Trey Young, was arrested on domestic battery charges, and Fulford allegedly contacted the prosecutor handling the case, someone who had previously worked for her and advocated on Trey's behalf. She reportedly helped draft a deferred prosecution agreement, attending meetings and even visiting him in jail after hours. The Judicial Committee considered her actions a clear overstep of professional and ethical boundaries. So they believe this because she effectively, if this is all true, inserted herself into a case involving someone close to her. So despite the seriousness of these allegations, Fulford never faced a public trial. As the investigation gained momentum, she went on medical leave and stepped away from the bench. The medical evaluation concluded she suffered from a, quote, permanent disability that impaired her ability to perform judicial duties. And based on this finding, the committee recommended involuntary retirement, which the Florida Supreme Court approved in September 2015. So, some legal professionals speculate that Fulford may have used the disability claim to sidestep the ongoing misconduct proceedings. You can see where minds go there. So while the disability paperwork is sealed, we don't know what exactly caused her to be permanently disabled. There was someone who recently spoke on the Surviving the Survivors podcast with Joel, who may know more about this. Surviving the Survivors has been covering this Adelson case for years. They do an excellent job over there. So the person that spoke about this is Stephen Webster, who is actually one of Dan Markel's former divorce attorneys and is reportedly on the witness list for Donna's trial. And well, we already heard from all of the state's witnesses, and I'm not sure in what capacity he could be used as a defense witness, so maybe he's no longer being called, right? I don't know. But regardless, he also knew Jackie Fulford personally. So let's see what he had to say. Take a listen to this.
Guy doing us a huge favor. Stephen Webster coming to us from across the pond while on vacation. That's how amazing our best guests are. He is a Tallahassee defense attorney. He's also Dan Markel's post-divorce attorney, and he's also on the witness list to testify at this upcoming trial, so a very special guest to have this evening. And certainly last but not least, we've got Dr. Melissa Hamilton. She was once a corrections officer, once a police officer. She hails from the great state of Florida, and now she is a professor of law at the University of Surrey in the UK. First off, Stephen Webster, thank you so much for doing this while you're away. And a lot of people said to me, hey, this guy's testifying soon, isn't he? Why is he coming on STS? So, Stephen Webster, why are you coming on Surviving Survivor?
Because I want to speak for and all the Markells. Before I ever did any media, I reached out to them and I said, do you mind if I do some media? It was actually 2017. And I was kind of concerned that nobody was ever going to be held accountable. And, you know, frankly, I knew Jackie, you know, for a long time. When she was faking cancer, she had me believing she was dying of cancer for years, me and my wife. Well, one of our best friends was actually dying of cancer. And she had us believing she was dying of cancer. It turned out that wasn't true. Okay? So, you know, frankly, she wants to take a shot at me. Like, she'll never hold me in judgment, ever, because I have absolutely no respect for that woman, okay? Kathy Ray was a prosecutor we worked with that was one of Jackie's dearest friends, one of my wife's dearest friends, one of my dear friends, somebody who was an amazing human being. Kathy Ray fought for the little people. She like prosecuted the most horrific cases and won. She was amazing, and she was dying of cancer, while Jackie had me believing she was also dying of cancer, which it turned out that there was no evidence to ultimately support that. So anyway, so you asked that question. That's a long-winded answer, but I wanted to get that off my chest. I came here tonight to say that here and now. Yeah, so I was a young prosecutor. I went to law school later in life, but in terms of my professional career, I was young as a lawyer. And she was my supervisor, and she was honestly a great supervisor. I'm not gonna lie. I mean, Jackie was a great trial attorney. She was. I felt like she did the job with a high level of ethics. I remember I had a case that involved methamphetamines, and when we were like all about taking down meth people, and I didn't think I could establish a prima facie case of guilt. I went to her, and she was my supervisor, and she said, "You need to drop the case," which took a lot of courage for her to say at that time. But anyway, so we worked closely together. I mean, as anybody can probably understand, you know, when you work in any sort of environment, you know, you become more than just co-workers. You become colleagues and ultimately, oftentimes, friends. And we believed that she was our friend. She officiated my wedding. She read the vows at my wedding. And it was kind of when Lance Armstrong was going through his cancer stuff. She had us believing that she had cancer. And she would leave and be out of the office for what we believed were cancer treatments and things like that. It just kind of like went on, and like, I didn't think anything of it. You know, I'm not a doctor, so I don't know how that works. And I know cancer can raise its head in many various forms. So it went on, and as I've already spoke about, one of our colleagues and friends, loved ones, Kathy Ray, actually got cancer, and it was a pretty vicious cancer, and took her out, unfortunately, in a couple of years. And like while that was going on, Jackie had us believing that she was also fighting a similar battle. And, you know, as I reviewed her medical records, but when it all came out, and I do believe it was part of the complaints, with respect to her sitting as a judge, that ultimately she stepped down from the bench, as a settlement, involved those false allegations, and I believe there was some sort of mental health counseling that was required as part of the settlement. But no, it doesn't sit right with us over here, okay? Those of us that knew Kathy, right? Like, first of all, it's gross.
We're almost done with day
It's just a
7,
human
y'all.
being. Any of us who've lived, we've known people that, were either afflicted with cancer, died of cancer, or their families were affected by it. So, I mean, just there and there, like, it stops. But for us, it's much deeper, because while we were watching Kathy fade away from us and we were losing her, we came to realize at the same time, it appeared that there was this sham going on, being perpetrated by Jackie, at the same time. So, yeah. So she can take shots at me if she wants, but she'll never hold me in judgment, ever.
As Troublemaker Baker said in chat, Surviving the Survivor SDS is deeply plugged into this case, and we have a link to that full interview in the description of this episode. We also just had that in chat. So go head over to Surviving the Survivor. Like I said, they are fully in this case, knowing a lot of people personally when it comes to this case. And while Fulford is no longer a judge, despite her permanent disability that we don't know about, because she is back in private practice based in Tallahassee, taking criminal defense clients that include Donna Adelson. I'm not sure whether any of this will impact Jackie's ability to represent Donna, and from what I've seen, she and Zellman have been handling things pretty well. Honestly, I feel that they're doing what they can to challenge the state's case, highlight any potential weaknesses or holes, doing their best, right? Just doing their best. I just found this background information interesting, but I would love to know your thoughts. I'd also like to know your thoughts about what you think about day 1 of defense. I saw some great comments in chat. I'm curious. It's always good to see what you guys are thinking after a day of a Donna Adelson trial and day 1 defense. It's been interesting. That's all we have for tonight. Of course, I'll be back again tomorrow, despite being out of town. I'm here to bring you what happens on day 8, and if the defense can actually...
This is day 8.
...out of the area. She emphasized that Wendy's design... Hello, Jens. Day 8 of the Donna Adelson trial. What a recap. Spoilers or no spoilers? I think most of you know. But for that handful that don't know, we'll say no spoilers. Let's just jump in. Day 8 of the Donna Adelson trial kicked off with some housekeeping before the jury even came in. The defense raised an issue, saying that a potential witness had backed out after being contacted by the sheriff's office. According to that, this person was originally going to testify, but later said she is on leave and unavailable. The judge explained that unless someone is subpoenaed, the court can't force them to cooperate if a witness doesn't want to talk. There's not much that can be done. To clear things up, a corrections deputy was called to the stand. She testified that their captain had gotten word that Donna's attorneys wanted to meet with Deputy Franklin at the jail. Franklin asked if she had to speak with them. And after checking with general counsel, the answer was no. She didn't have to unless she was subpoenaed. It was completely voluntary. Importantly, no one ever told Franklin not to talk. The defense suggested the sheriff's office had blocked their access to a witness, but the deputy's testimony refuted the claim. In fact, she clarified that Franklin isn't out on leave at all and is still available. The defense would just need to go through the proper subpoena process, so After that was cleared up, the first witness of the day, here we go, was Kristen Adelson, a family lawyer with nearly 4 decades of experience.
Okay,
She's
family
been
lawyer.
board certified since the mid-90s, served as president of Florida's top matrimonial law group, and is even a fellow in international family law. So, quite impressive. And this is the defense's next witness. So, the defense called Adelson to push back on the state's framing of Wendy and Dan having a bitter custody battle. That was in quotes, bitter custody battle. So, she told jurors that what Wendy went through wasn't that at all. It was a relocation case, which is a very different type of dispute. So Adelson explained that relocation cases are tough because they're essentially win or lose situations. One parent moves, the other stays behind. While rare overall, she said they're not unusual in Tallahassee because so many jobs and universities draw people in and out of the area. She emphasized that Wendy's design it's common for parents to want to be closer to their families, and she's seen plenty of cases where family members are very involved in their adult children's divorces, even sitting in on meetings and mediations. Still, she told jurors these relocation cases are extremely difficult to win. Adelson said she warned Wendy from the start. Leon County courts generally lean against relocation, and at best, her odds were 50-50. She testified that in her 37 years practicing law, she had only won one relocation trial. Negotiated moves sometimes work, but judges approving them outright is rare. And Wendy's case fit the usual reasons. Young children, family ties, a solid job offer in Miami, but it wasn't enough. Adelson said she made it clear this was Wendy's one shot because post-divorce modifications are nearly impossible unless the kids are facing serious harm. Adelson also explained how Florida's financial disclosure rules work, though. Full tax returns, bank accounts, retirement funds, and property have to be listed and sometimes evaluated by experts to separate marital from non-marital assets. She confirmed that Wendy testified in court about the Miami job offer, but the judge ultimately denied the relocation. So according to Adelson, the judge even pulled the lawyers aside mid-hearing and admitted she understood why Wendy wanted to move, but didn't think it was in the kids' best interest. And that essentially signaled defeat before Dan's side even presented its case. At that point, Adelson and the opposing attorney encouraged their clients to stipulate to a denial with prejudice, meaning Wendy could not try again. Wendy agreed, knowing her best chance to move had already slipped away. And after the relocation was denied, the focus shifted to negotiating parenting schedules and dividing up finances instead of fighting it out in court. Mediation followed, and Adelson said Wendy stayed calm, understood the law, and seemed resigned to the loss. Talks nearly wrapped everything up, and within a week, the divorce was settled outside of trial. So Adelson emphasized that settling gave both sides more control than leaving the outcome in the judge's hands. She also explained how mandatory affidavits and financial discovery work in family cases. Wendy had a Charles Schwab retirement account that was partly marital and partly non-marital, so they even called Schwab representatives during mediation to clarify the details. Full transparency was required. Dan also had about $500,000 in non-marital Schwab funds. Once both sides understood what was marital versus non-marital, they finalized a marital settlement agreement. Adelson said that tied up the loose ends without needing major evidentiary hearings. So after the divorce between Dan and Wendy wrapped up, Wendy invited Adelson to what she called a, quote, get her groove back party at her new place in Tallahassee. It was meant as a light-hearted celebration of moving on. Adelson went with friends and remembered Wendy presenting herself as being in a good place after the divorce. Adelson testified that the divorce cost about $30,000 in fees and expenses, which she considered relatively modest for this kind of litigation. aside from the relocation issue, there weren't any other contested hearings until later after the divorce. The defense highlighted that under the settlement agreement, Dan owed Wendy $120,000 for her share of the marital home and another $10,000 toward her attorney fees. But he only paid $50,000, leaving a large balance. Adelson filed to enforce the agreement, pointing out that Dan had significant assets. Instead of paying, Dan brought in new counsel and pushed back, accusing Wendy of hiding money. Earlier in trial, the state pointed out that Dan had accused Wendy of concealing her Charles Schwab funds and retirement accounts. But the defense countered that those assets actually were already disclosed and even discussed during mediation during the divorce. So take a listen.
Did that prompt Mr. Markell today?
No, I did not.
What happened?
So then Mr. Markell hired a new lawyer. And his new lawyer filed a responsive pleading to that by motion, basically saying that he shouldn't have to pay because Ms. Adelson had breached the marital settlement agreement.
How did he allege that she breached the settlement agreement?
He filed multiple motions.
Back in a
His first
second.
responses and motions. His first one, basically, if I remember correctly, was all about the money. And he said that he shouldn't have to pay because she had hidden the Charles Schwab money from him, and he used to have power of attorney, so he knew that she hid the money, which doesn't make sense. If he had power of attorney, he would know what the money was, so it didn't make sense to me. But anyway, that she had hidden that money, and that she hadn't told him about several other of her retirement accounts, and therefore the marital settlement agreement was breached, and he shouldn't have to pay her money.
So you filed a response, but did he seek to have the settlement agreement itself voided or set aside?
He did not. So, and that is what I told Wendy at the time, is that it's not a proper defense for not paying the money. Professor Markell, it was pretty obvious that he had actually written this plea himself, and the lawyer just signed off on it. It had footnotes, which is not something litigation lawyers would do. It was voluminous, and it was very personal about what was going on and Wendy and how I don't think at this point he alleged that he might have alleged that she had committed fraud. But an appropriate pleading would have been for him to file a 12.540. That's kind of technical, but basically, if you think that an agreement is reached and it is not in good faith, or there's assets that were not provided, then you must file within a year for a 12.540 to have the whole agreement set aside. You can't just say one good breach is another. And I filed a pleading basically saying that his motion should be dismissed because it was inappropriate. And
You filed a motion to strike as a sham pleading?
I did. I filed a motion saying this is an inappropriate pleading and it should be dismissed. Because it wasn't the correct way to go about doing what he wanted to do. And so I then tried to set hearings on those motions so that we could move this forward and everybody could get paid.
Adam testified that she told Wendy the fraud allegations weren't being handled correctly. If Dan truly believed there was fraud, he needed to file a motion to set aside the agreement under Rule 12540 within a year, not just to refuse to pay what he owed. In February 2014, the judge criticized Dan's pleadings as inappropriate and even called them, quote, eye-poking. Still, she allowed Wendy to be deposed, though with certain limits. Adelson said she stepped in to protect her client during this process. Dan also started raising parenting complaints after the divorce, accusing Wendy of blocking FaceTime calls, avoiding shared birthday parties, letting Donna babysit too much, and even alleging parental alienation. His filings escalated further, suggesting that Wendy should be disbarred, and even began targeting Adelson herself. The defense painted these as frivolous attacks while still pressing forward on the unpaid settlement money. On the issue of alienation, Adelson explained that the term parental alienation isn't clinically recognized, though real cases do exist for when parent improperly influences children against the other. But she emphasized that even if Dan's claims were true, they wouldn't have justified limiting Wendy's parenting time. As the filings became more personal, accusing her of fraud and calling for disbarment, Adelson realized she had essentially become a witness and withdrew from representing Wendy. She brought in attorney Jimmy Jenkins to take over, which forced delays while he got up to speed on the case. For the defense, Adamson's testimony helped in two ways. First, it showed that Wendy's relocation fight was always an uphill legal battle. And second, it undercut the idea that Donna was doing everything. Adelson said Donna and Harvey were never involved in Wendy's legal meetings or strategy. They only showed up briefly at the relocation hearing, and even then they stayed out in the hallway. Her withdrawal as Wendy's attorney showed how toxic the litigation had become, while her testimony chipped away at the state's narrative of Donna as being in control. Well, let's go though to cross-exam. On cross, Sarah Dugan pressed Adelson on whether Donna was secretly writing Wendy's court filings. Adelson shut that down, saying she herself drafted the documents. At most, Wendy gave limited input, and if there were any edits exchanged between mother and daughter, Adelson said she never saw them. Well, Dugan also suggested that Donna and Harvey were more involved than just sitting quietly on the sidelines. Adelson acknowledged that in relocation cases, families often carry unrealistic expectations and sometimes push harder than the client. But in her experience with this case, Donna was polite, not disruptive, and stayed in the hallway during the relocation hearing because she could have been called as a witness, not because she was disengaged. Adelson confirmed that after the divorce, Dan refused to pay what the settlement required, claiming Wendy had hidden assets. She dismissed those claims as legally baseless and filed motions to enforce the agreement and hold him in contempt. She clarified, though, that this wasn't the kind of contempt that could land someone in jail. It was limited to financial enforcement, not like child support or alimony. Dugan circled back again to the accusation that Donna was writing Wendy's legal documents. Adelson repeated her answer. She wrote all of Wendy's pleadings, and if any drafts or edits were shared between Wendy and Donna, they never made their way to her. Dugan reframed the point, arguing that families often insert themselves in custody disputes, which leaves room for influence even without direct involvement. And Adelson admitted that that kind of pressure is common, but she maintained that in this case, Donna and Harvey were not steering her strategies. When asked why the Adelson sat outside the relocation hearing, Adelson explained that it was because they were potential witnesses. She described them as, quote, very nice people, but did note, that Wendy consulted with them privately after the judge denied her relocation request. Dugan also highlighted how Dan's filings escalated, accusing Wendy of fraud, pushing for her disbarment, and even trying to restrict Donna from babysitting. Adelson agreed things got personal, but she still resisted labeling the divorce as especially contentious. Finally, Adelson confirmed that she withdrew from the case after Dan accused her of fraud, knowing she'd likely become a witness. The hearing never took place because Dan was murdered. Reflecting on that, Adelson told the court, quote, "It's rare, but I've had clients murdered before. I remember all of them." End quote. That was said. On redirect, the defense pointed to Dan's March 26, 2014 filing, where he asked the court to restrict Donna's unsupervised time with the grandchildren under the, quote, right of first refusal, citing claims that she had made disparaging remarks about him. Well, Adelson clarified that she didn't step away from the case because of Dan's personal attacks. The only reason she withdrew was that she anticipated being called as a witness, which created a conflict. Without that issue, the hearing would have gone forward in May 2014. Zellman also emphasized that after the relocation request was denied, Donna appeared to accept the judge's decision. Adelson agreed with that, though she couldn't speak to whatever Donna may have said privately afterward. Finally, Adelson stood firm on the filing. She alone drafted all of the pleadings. While she relied on Wendy to provide factual details, she did not take legal arguments from her, and Wendy's input was minimal. The judge turned next to the issue of witness sequestration, revisiting sidebars from the prior 2 days about whether the next witness, attorney Linda Bailey, had been in the courtroom before taking the stand. Prosecutors reminded the court that sequestration rules exist to prevent even subtle or unconscious influence on testimony. The judge directed both sides to check the sidebar records, confirm Bailey's status, and be ready to address it with jurors if needed. The state then moved to exclude Bailey altogether, arguing this was the second time sequestration had been violated. They claimed the defense wrongly advised Bailey that she could sit through Kristen Adamson's testimony despite these rules. The defense fired back, calling exclusion a, quote, drastic remedy. They pointed to Florida case law that says a witness can only be barred if their testimony is substantially tainted by hearing someone else's. They argued that proper remedy is to test Bailey's credibility in court, not to preemptively silence her. The judge agrees sequestration rules are about fairness, but stressed that exclusion is reserved for extreme cases. The only way forward was to question Bailey directly about whether she'd been influenced. So the jury was excused, and Bailey, a family law attorney, was then sworn in outside of the jury's presence for a proffer. She explained that she had been retained to evaluate whether the Markel-Adelson divorce was unusually contentious compared to typical cases. For her review, she relied on divorce pleadings, motions, and orders, emails and texts between Wendy and Dan, plus some or with Donna and Kristen Adamson's prior testimony. She even consulted Adamson directly for confirmation. Bailey admitted she asked to sit in on Adamson's testimony to confirm the facts, but she maintained her conclusions didn't change. In her words, quote, it was very consistent with what I believe the facts to be, end quote. The defense framed Bailey as bolstering Adamson's credibility, not undermining the sequestration rule. The state still pressed to strike her, but Bailey stood firm that nothing she heard altered her opinions. So then, on cross-examination, prosecutors pressed Bailey with a simple question. They asked if she learned anything new, that she learned anything you learned new today. Bailey? Oh, she said no, absolutely not. Proceedings paused as the court waited for Judge Everett's decision on whether Bailey, the defense's expert, could testify after being present at Kristen Adamson's testimony. And with the jury out, the judge ruled this was indeed a second sequestration violation by the defense. 2 now. Citing the case Steinhurst versus State, Everett explained that exclusion is only proper if a witness's testimony was substantially affected. And because Bailey testified, her opinions were unchanged, the judge allowed Bailey to proceed, noting her credibility as a member of the bar carried weight. The prosecution reserved the right to request a jury instruction later to challenge her credibility. The defense said they had no objection as long as the instruction was fairly worded, reminding jurors that it's their role to decide whether Bailey's testimony was truly influenced. Judge Everett stressed the importance of clarifying sequestration rules now to avoid any more violations. So after sorting that out, Linda Bailey officially, now finally, took the stand in front of a jury as the defense's next expert. She explained to the jury that she is a Tallahassee family law attorney with 37 years of experience, board certified in marital and family law since 2011, and a certified mediator. She's handled roughly 2,000 family law cases, and less than 1% of Florida lawyers hold that same certification. She's also been named to Best Lawyers in America, recognized as a super lawyer, and even taught pro bono attorneys family law basics for 5 years, focusing on parenting plans and relocation cases. Bailey testified that she reviewed the entire divorce file between Wendy and Adelson and Dan Markell from 2012 to 2014, along with texts between Wendy and Dan, emails between Wendy and Donna Adelson spanning 2011 to 2017, and some texts between Donna and both Wendy and Charlie. She also spoke with Wendy's former lawyer, Kristen Adamson, for about an hour. Bailey explained that Wendy filed for divorce in September 2012, and by October, she filed a motion for a temporary parenting plan. Bailey said that was a standard move in divorces involving children to create stability during the process.
As a military spouse, it was really important to me to find a program that understood my specific needs.
Standard move in divorces involving children to create stability during the process. Wendy asked for a 51/49 time parenting split, which is essentially equal custody, right? I was so confused when they said this at first, but Bailey added that the only reason for asking for 51/49 instead of 50/50 was likely for IRS purposes. The parent with 51% can claim head of household status and dependent deductions. She noted this was ordinary practice in family law at the time. And even though Wendy filed that motion, Bailey pointed out that she and Dan never actually went to court over this. Instead, they worked out a roughly 50/50 arrangement through their attorneys, which she said showed early cooperation between the two. Bailey also reminded jurors that Florida had stopped using the word custody in divorces by the early 2000s. By 2012, it was officially time sharing or parenting time language, meant to avoid one parent feeling like the lesser parent. From her review of the file, Bailey said she found no evidence Wendy ever tried to block Dan from having substantial time with the children, defined as at least 40% of overnights. She only saw 51/49, which in practice is equal parenting time. She noted there was just one contested hearing before the final divorce judgment, and that was June 21st, 2013. And at that hearing, Dan's motion to dismiss Wendy's relocation request was denied, and his motion to enforce informal child care arrangements was also denied. Bailey explained that he had been trying to enforce emails and child care recommendations, not actual court orders. Bailey testified that at the June 2013 hearing, after Wendy's relocation motion was denied, she decided to withdraw the request entirely. That decision also meant she waived her right to appeal. Within 5 weeks, Wendy and Dan signed a full marital settlement agreement on July 31st, 2013. The agreement covered everything. Wendy waived alimony, property was divided, child support was set, and a parenting plan was established. It also included a parenting coordinator to help mediate conflicts, able to enforce existing rules like timeliness, call frequency, and exchanges, but not allowed to add new terms. The goal, Bailey said, was to reduce litigation and conflict for the children. Bailey's expert opinion, the divorce was not unusually contentious. It wrapped up in just 10 months, which is faster than average, especially for a case that included a relocation dispute, which often takes 2 or more years. In her words, it was amicably settled. Everyone was moving on. Her testimony reframes the narrative.
If it was settled, what
Prosecution
happened?
has been pushing. If the dissolution was settled quickly and amicably, the idea that Wendy, and by extension Donna, were embroiled in a bitter, drawn-out custody war loses weight. Bailey added that from September 2012 to July 31st, 2013, there were no discovery disputes, no motions to compel, no subpoenas to bank, and no chasing third parties for hidden accounts. Compared to high-conflict divorces, the file was quiet. Only 2 non-party depositions were taken, Dr. Phelps from Creative Preschool and a law school staffer, both of which were routine and non-adversarial. Dr. Phelps even noted that the children were doing great. She emphasized that the law also matters here. Relocation fights are difficult to win, and Wendy's waiver of her right to appeal showed acceptance of the court's ruling, not defiance. Bailey left it to the jury to decide whether any later hostility was genuine escalation or if prosecutors were stretching an otherwise ordinary divorce into a motive for murder. Bailey reviewed emails between Donna and Wendy and saw nothing unusual about Donna's involvement. She explained it's common for parents, especially mothers, to hover during divorces. She said, quote, I see a lot of mothers. They're worried about their babies no matter how old they are, end quote. She told this to the jury. And Bailey confirmed that Donna sometimes called Dan, quote, gibbers, but she didn't find it provocative. She said it actually fit the style of Dan's own filings, which were verbose, inconsistent, and difficult to enforce. She called them, quote, very wordy and full of hyperbole. She also noted that Dan's pleadings looked self-written, not attorney-drafted, and contained contradictions, like accusing Wendy of hiding Schwab accounts while admitting he knew about them. She added, quote, you can't say fraud and then admit you knew. Bailey said Dan's 2014 filings had no real legal strength. Wendy had filed enforcement motions in October 2013, and Dan waited until January 2014 to respond. He admitted he hadn't paid, but claimed that Wendy's, quote, bad behavior excused it. Bailey said that argument was not legally strong. Looking at Donna's emails after the relocation denial in June 2013, Bailey noted that Donna was upset and asked if the decision could be reversed. Wendy responded, quote, Mom, I am at peace. I'm good, end quote. Bailey said there was no further push, and after July 2013, relocation wasn't raised again. Bailey explained to the jury that it's routine for parents to insert themselves into divorces. In cases where parents are heavily involved, she sometimes even invites them into mediation sessions. She said, quote, I want them to hear my advice so they don't second guess at home. It keeps everyone on the same page. Bailey testified that Wendy ended up with about 55% parenting time until the children reached school age, then 50-50 afterward. By contrast, Dan wanted sole decision-making, kosher restrictions, more than half the assets, and equal birthday splits. And he got none of it. But in reality, most things went in Wendy's favor. Wendy secured shared responsibility and an equal division of assets. Dan was obligated to pay her $120,000 and $10,000 towards attorney fees due to their gap in resources. From September 2012 to July 2013, Bailey described the case as, quote, not contentious. There was only one partial hearing and everything else was resolved in about 10 months. After the judgment, Dan only paid part of what he owed. Wendy waited past the deadline before filing an enforcement motion, and she did not request any drastic sanctions. Texts from 2014 showed Dan and Wendy adjusting parenting exchanges for travel and even sharing ice cream outings with the boys. Bailey noted that despite pending motions, they managed well and maintained cooperation with each other. Bailey reviewed Kristen Adamson's October 31st, 2013 motion. While it was titled, quote, enforcement and contempt, its focus was that Dan had not paid Wendy $120,000 plus $10,000 in attorney's fees. So inside the motion's wherefore clause, Adamson didn't request jail time or punitive sanctions. She asked the court to order Dan to transfer the remaining $120,000. Also to pay the $10,000 in attorney fees and cover interest and any extra fees incurred to force the motion. Bailey explained this was routine, essentially a collection tool. The only risk to Dan was paying statutory interest and additional attorney fees, not jail time. Bailey also reviewed December 2013 emails. Dan wrote to the parenting coordinator and Wendy complaining that Donna had allegedly called him stupid. Bailey said that he only wanted Wendy to be mindful not to outright ban Donna from seeing the boys. Despite raising the claim in emails, he didn't file any legal motion at that time. Bailey emphasized to the jury that the Adelson-Markell divorce was ordinary, routine, amicable, and much easier than high-conflict cases that rack up $500,000 in costs, involve multiple experts, and drag through discovery battles. By contrast, Dan's filings were verbose, hyperbolic, and lacked foundation. Kappelman went after Bailey on cross, challenging her characterization of the divorce as routine. She pointed out that while lawyers might see it as standard, to the parties involved, it could feel like the most important thing in the world. Bailey pushed back, describing the pleadings as, quote, annoying but not emotionally charged. Kappelman pressed on the impact, noting lives are upended in divorce. Let's take a listen to this.
That a case, as a lawyer, might be routine, whereas to the parties, it's the most important thing in the world.
To some degree, that's one reason I call Kristen, is Ms. Adelson, in particular, of the lawyers in our community of the family law bar, is extremely measured and calm. And I find that when I litigate against her, we reach resolutions, that people stay measured and calm, and we get things done. She's not one of the other lawyers in town who may stir cases up or play on those emotions. So our job as lawyers is to explain to our clients when we get a motion. If I get something, for example, that, although I've never had something similar to what Mr. Markel would file, the immediate response is to call your client and go, I know you're going to read this at first glance, it's going to seem messy, but there's no legal basis for this, so don't worry. And my understanding is that is what she communicated to Wendy.
And when you communicate these things to your clients, hey, this is no big deal, this is no problem, this is a bunch of gibberish, do they always accept that?
Well, that's not the way I would present it, but...
Do they ever get upset about the gibberish in the pleadings, the offensive materials in the pleadings, regardless of whether or not it's going to impact their chance of success in court? It can be emotionally charged, can it?
Well, I would say annoying more than emotionally charged.
You would not say that divorce and child custody issues are emotionally charged?
They can be, but in this case, they weren't.
They weren't? How do you know?
From the pleadings, because I don't have 10,000 pages in front of me.
You're not in the mind of the people whose lives are impacted by these pleadings. It's not just about pieces of paper and a binder, is it?
I don't think that's what I said.
People's lives are impacted by the decisions that go on in court, which for you are routine. Would you agree?
In this instance, they reached agreement on all issues, so they had complete control of what was coming out of the court.
Ma'am, could you please answer my question? Are people's lives impacted in drastic ways by routine matters that we see in court as lawyers?
People's lives change after divorce, certainly.
So, like, I may think I've got a bag of stinky garbage, but the garbage man might not think it's stinky at all. You get the reference?
I don't.
What is no big deal to us is a big deal to these litigants, right? You can't agree with that. You can't agree with it.
Kappelman then asked about money. She said, quote, $80,000 is a lot of money, isn't it? Bailey replied, depends who you are. When pressed on contempt, Kappelman suggested jail was the way then court can enforce payments. But Bailey disagreed. She said, quote, I don't see any possibility he was going to end up in jail. Jail was pretty far-fetched. Kappelman returned to language, emphasizing the anti-Semitic connotation of the word gibbers. Bailey clarified she had thought it meant someone who speaks gibberish, but admitted it wasn't flattering. Again, she insisted she'd seen worse in other cases. Kappelman also asked, quote, isn't alleging grandma disparaged dad fuel for anger? Bailey maintained there was no proof and it shouldn't have been taken that way. She said that even baseless claims might carry emotional weight, but in her view, they were just annoying. Kappelman raised the stakes, asking if Bailey had ever had clients die from family litigation. She admitted one Middle Eastern man killed himself the day after a petition was filed, seemingly due to cultural shame. The point was clear. What seems routine to lawyers can be life-shattering to the parties. Kappelman pressed again, asking, quote, what is routine to you may be life-changing to them, isn't it? Bailey tried to hold her ground, saying agreements were reached and this case wasn't high conflict. Kappelman snapped back, saying, quote, you're not in their minds. It's not just paper in the binder, is it? Despite the pressure, Bailey stood firm that the Adelson-Markel divorce was routine. She emphasized the pleadings didn't justify extreme outcomes. They were just baseless motions, not proof of hostility. She told jurors she saw no evidence that Wendy copied Donna's suggestions into Adamson's filings or that Wendy relayed Adamson's answers back to her mother. Bailey acknowledged Donna was upset right after the relocation denial, but she saw no post-settlement email showing ongoing anger. Here, Kappelman pushed back some more. Let's keep listening to Kappelman.
If Dan Markel had agreed to the relocation post-denial, post-stipulation, post, it could still happen, right? I mean, if he agrees, it could happen.
Sure, he agreed. She could have relocated.
All right, and if he was murdered, it could happen, right?
Obviously.
She reiterated that Dan's pleadings were mostly baseless. They lacked legal merit and would never have succeeded, but Kappelman highlighted the emotional side, pointing out that even meritless filings can be inflammatory and upsetting to the parties and family. Bailey agreed, saying, quote, sure, nobody wants to read those allegations, true or not, about themselves in a public record. Kappelman then turned to the timeline, pointing out that at the time of Dan's murder, litigation was still ongoing with hearings scheduled for May 15, 2014. Bailey agreed and added that she believed those hearings would likely have favored Wendy, potentially forcing Dan to pay her attorney's fees, the kind of ruling that usually deters further filings. But she acknowledged, quote, we'll never know because he was murdered. And with that, Bailey was released. The court then broke for lunch, and during recess, the defense would decide whether Donna would testify. Judge Everett reminded both sides that any remaining witnesses must stay out of the courtroom to avoid further sequestration violations. And lunch outside the presence of the jury, Donna was sworn in. Her former attorney would take the stand, but only after Donna waived her attorney-client privilege. Judge Everett pressed the defense to make a firm decision. Would Donna testify? Or would she exercise her right to remain silent? The defense argued they needed more time to review 6 days of state evidence with her, but Judge Everett granted only 5 extra minutes, saying they've had plenty of time. Tensions rose and the defense flagged repeated laughter and comments from the gallery, claiming it was affecting Donna's ability to decide. They requested a limited sidebar with Donna, but their decision on whether she'd testify wasn't yet announced. They kept us hanging, didn't they? Court resumed after the extended lunch break, and Judge Everett ordered the jury back into the courtroom. And next on the stand was Marcel Descalzo, a criminal defense attorney who had been practicing since 2003. She began representing Donna shortly before her arrest. Descalzo testified that in late October 2022 through early 2023, while Charlie was on trial, she began noticing concerns about Donna's mental state. Donna allegedly made multiple statements about self-harm if Charlie was convicted. Descalzo said she realized she needed to act. She first confirmed with Daniel Rashbaum, Charlie's attorney, and together they decided to contact their ethics counsel and the Florida Bar to determine whether additional steps were required, such as the Baker Act evaluation or involuntary commitment. Afterward, Descalzo and Rashbaum spoke with Donna further. Let's listen to this.
After doing that, did you have further discussions?
I'm still here. I'm just eating.
About her mental state and what she was going to do to try to clear things up.
Mr. Rashbaum and I spoke to her further, and, you know, she told us that what she really wanted to do was she wanted, you know, to get away on a vacation with her husband. Her husband agreed that this would be good for her mental state, and so we discussed a potential vacation.
At that point in time, was there anything preventing Mrs. Adelson from traveling?
As far as Mr. Rashbaum and I knew, there was not.
And specifically, there were no warrants for her arrest.
My understanding from speaking to Mr. Rashbaum, that Mr. Rashbaum had communicated with law enforcement and that there was no outstanding warrant. I had been in touch with the prosecutor of this case, and I apologize because I only remember your first name, but with Georgia. And we had discussed previously, not around this time, we had previously discussed that I represented Mrs. Adelson. So I assumed that if anything would happen, that if there was a warrant or if Mrs. Adelson was going to be arrested, that I would be contacted.
Did you advise Mrs. Adelson that if a warrant was issued, that you would provide her with that information so that she could self-surrender.
So the discussions I had with Mrs. Adelson weren't exactly like that. Mrs. Adelson discussed what would happen if there was an arrest warrant, and the potential things that might happen. The prosecutor had never guaranteed for me that Mrs. Adelson would self-surrender.
Did you tell her did you tell Mrs. Adelson that self-surrender was something that could happen?
Yes, I did.
And on November 6th, her son was convicted. Did you speak with her after that, specific as to her ability to travel?
I don't remember the dates, but there was discussions about her traveling after the conviction, because around that time was when she was making a serious threat, was when Mrs. Adelson was making serious threats about her life.
Just a moment, Your Honor.
Said what she really wanted was to get away and take a vacation with Harvey. They all agreed that a short trip could be beneficial for her mental state. At that time, nothing legally prevented Donna from traveling. The attorneys even checked with law enforcement to confirm that she had no outstanding warrants. Descalzo also stayed in touch with Georgia Kappelman, who knew Descalzo was representing Donna. She assumed that if anything changed or if authorities planned to arrest Donna, Kappelman would inform her. Descalzo also assured Donna that if she was ever aware of a warrant, she would let her know so Donna could potentially surrender voluntarily. After Charlie was convicted, Descalzo spoke with Donna again about taking a vacation, noting that Donna's mental health had become very fragile and she was expressing thoughts of self-harm. On cross-examination, Sarah Dugan asked if someone with a warrant can dictate the terms of their surrender. Descalzo explained that's usually up to law enforcement, though sometimes they're allowed to self-surrender as a courtesy. It's not a requirement to notify someone about a warrant, and if a person is considered a flight risk, that courtesy is less likely to be granted. She clarified that she spoke with Kappelman before Charlie's conviction, but Kappelman never guaranteed that Donna would be able to self-surrender if a warrant were issued. Dugan then asked if Descalzo had disclosed to anyone in the state's attorney's office that Donna was going to self-harm. She said no, citing attorney-client privilege. When asked why Donna was suicidal, Descalzo said it was because she feared Charlie would spend the rest of his life in prison. Dugan asked whether Donna was worried about being convicted herself. Descalzo said she didn't believe that was on Donna's mind at the time. Her focus was entirely on Charlie. Dugan asked if Descalzo was aware of a text Donna sent to Wendy suggesting she was afraid that she might be next, but that Wendy shouldn't worry because Donna would, quote, take care of that. Descalzo said she was not aware of texts Donna sent to others. And next, Dugan asked about a conversation where Donna indicated she might or might not make it to the airport. Descalzo testified that she told Donna that even if there were no known active warrants, it didn't mean she couldn't be arrested at the airport. Next, Dugan asked if Descalzo knew whether the Adelsons' planned vacation was to Vietnam, China, or Korea, countries without U.S. extradition agreements. And Descalzo said she was not aware of where the Adelsons planned to travel. Finally, Dugan asked Descalzo whether law enforcement overhearing Donna talk about ending her life or fleeing the country could have affected their trust that she'd be willing to turn herself in. Descalzo said she wasn't law enforcement, so she couldn't say for sure. But as Donna's attorney, she believed it would make things more difficult. On redirect, Zellman revisited the state's line of questioning about the fleeing the jurisdiction. He and Descalzo clarified that Donna never expressed a desire to flee. She said she wanted to take a vacation. Zellman then asked if Descalzo had ever dealt with extradition from foreign countries. She confirmed she had and explained that being in a non-extradition country doesn't mean the U.S. can't try to secure someone's return. She added that if the person is a U.S. citizen, the government can absolutely still attempt to bring them back. And next up on the stand was Sarah Newhouse, a former victim advocate for the Tallahassee Police Department. She explained that her role was to support victims and act as a liaison between them and law enforcement. On the day Dan was shot in 2014, Newhouse served as a victim advocate for Wendy. She was present when Wendy called Donna to let her know what had happened. In Newhouse's opinion, Donna sounded shocked. It seemed to be the first time she was hearing the news. Defense Exhibit 71, a recording of Wendy's call to Donna, was offered into evidence for the jury to review later. At the prosecution's request, Judge Everett ruled that any comments before and after the call, including unrelated remarks, would be cut. The call was officially admitted, but only the trimmed portion, showing Donna's immediate reaction. On cross-exam, Kappelman questioned Newhouse about Donna's reaction. She asked if she heard any wailing during the call. Newhouse said no, and noted that she had never met Donna in person, so she couldn't compare her reaction to what might be considered a normal demeanor. Kappelman also brought up that Wendy had remarked that Donna, quote, handled it well, but the judge immediately struck that question and instructed juries to disregard it. Newhouse stepped down after cross. The defense stated they had no further witnesses lined up, none at all. So attention turned to the most asked question: would Donna take the stand? We were holding our breath, and Judge Everett reminded Donna that she could testify or remain silent, and that her silence could not be held against her. Also saying that testifying would expose her to cross-examination and scrutiny of her credibility. Donna, she hesitated, telling the court, quote, "I'm not prepared to make the decision. This decision affects the rest of my life." End quote. Yes, it does. Everett emphasized that she was in the same position as any criminal defendant and ultimately had to make her own choice. Donna requested more time, saying she wanted to consult with her church, but her clergy had already left. Everett pressed again, asking what she intended to do. Visibly firm, he reminded the courtroom that Donna had already had ample time. He said, quote, "What exactly are we going to accomplish now that we have not been able to since the trial started, pre-trial, the long recess yesterday, or even lunch break today?" End quote. Well, Donna ultimately declined to testify, to my disappointment. Clearly, I'll admit it. By exercising her constitutional right to remain silent, Everett confirmed that the jury would be instructed that this cannot be held against her. And after that, the defense officially rested its case. There you go. Boom. Kappelman indicated the state would not present a rebuttal, though a brief conference was planned for confirmation. The defense announced they would tender 2 exhibits for admission. Even after a party rests, the court can still allow the admission of exhibits without calling another witness, as long as the evidence is properly authenticated or tied to a foundation. However, the state immediately objected on hearsay grounds, prompting a sidebar to determine whether the evidence could be admitted. The defense argued the exhibits were necessary for completeness. Earlier, the state had introduced excerpts from Donna's 2014 and 2023 calendars. The defense now wanted the court to admit the full calendars, claiming the jury needed the full context beyond the state's selective entries. The prosecution pushed back, saying the defense could not use the rule of completeness to introduce entire calendars. The excerpts had been admitted for specific purposes only. The rest, they argued, was self-serving hearsay. They noted, quote, "It's a day planner, not a narrative," end quote. The defense countered, arguing the state cherry-picked pages from Donna's 2023 calendar that showed items to sell, suggesting panic sales before her potential flight. They claimed admitting additional pages would show these listings were planned long before any Vietnam trip, undermining flight risk arguments. The judge ruled that the defense could not blanket admit the full 2023 calendar. Completeness applied differently to recordings than to day planners. Each page must be tied to a witness and have proper foundation. So then the defense didn't give up. The defense narrowed their request, seeking only the pages the state had already highlighted regarding items for sale. Everett took the matter under advisement, noting that not every calendar entry has value, and without witness foundation, most entries are irrelevant hearsay. The defense may argue the point in closing, but admissibility remains unresolved. The prosecution emphasized that the 2023 page admitted at Charlie's trial that had a specific tie to license plate numbers, unrelated entries like birthday planning, do not complete that context. Regarding that 2014 calendar, they argued that only the license plate page had ever been relevant, and that party planning notes added nothing. They demanded complete redactions of any unrelated material if the judge allowed the defense to admit more. Judge Judge Everett held off on ruling, reserving judgment on whether any 2014 planner entries could be shown to the jury. And for now, the jury will not see them. So again, since the defense has officially rested, jury instructions and closing arguments are set for tomorrow.
Domino's Best Deal Ever is back. Get your dream pizza for just $9.99 online. Order now.
For tomorrow. Dun, dun, dun. And after the jury left, Judge Everett began reviewing the final jury instructions. Both sides could raise objections or propose changes as each section was discussed. Everett started with instruction 3.1, the standard introduction, with no objections or changes. Instruction 3.2, the statement of charge, was adjusted stylistically at the defense's request. The word charge would no longer be in all caps. Instruction 7.1 covered the mandatory introduction to homicide. It stated that Donna Adelson is accused of first-degree murder under count 1. No changes were requested. Judge Everett confirmed that the defense requested all Category 1 lesser-included offenses for count 1, meaning the jury will be instructed on first-degree murder, second-degree murder, and manslaughter. References to the victim will match the indictment, naming Daniel Markel. Definitions for justifiable and excusable homicide were removed, so the jury will only consider first-degree murder and its lesser-included crimes. The final instruction to jurors: they are to consider the circumstances that must be proved before Donna may be found guilty of first-degree murder or any lesser-included offense. Judge Everett moved on the elements of first-degree premeditated murder. To convict, the jury must find that Daniel Markel is dead, that his death was caused by Donna Adelson, and that the killing was premeditated. No felony murder theory will be presented. The defense requested a stylistic change, asking that jury instructions avoid all full caps to prevent unduly highlighting the charges. Everett confirmed that definitions for act, killing with premeditation, and question of premeditation would be included. The heat of passion instruction was taken out, though, due to lack of supporting evidence. Instructions 3.4 on lesser offenses moved forward with the same stylistic adjustment, covering second-degree murder. And for that charge, the jury must find beyond a reasonable doubt that Daniel Markel is dead, that Donna Adelson caused his death, and that the killing was unlawful, imminently dangerous, and showed a depraved mind without regard for human life. Everett confirmed that imminently dangerous and depraved mind definitions would be given. An intent to kill is not required for second-degree murder. Heat of passion is again excluded. Next, Everett reviewed manslaughter. To convict, the state must prove two elements beyond a reasonable doubt. First, that Daniel Markel is dead. Second, that Donna Adelson either intentionally committed an act causing his death or intentionally procured an act that caused it. The procurement theory ties her to arranging the act rather than directly committing it. Everett clarified the language from the case State v. Spencer, and instructions on excusable or justifiable homicide are omitted. Everett asked Donna if she understood what was being removed from the jury instructions, and Donna confirmed that she did. The defense formally conceded that the homicide will not be framed as excusable or justifiable. Judge Everett confirmed with Donna that she understood and consented to this concession. Donna requested a little more time with counsel, which was granted. Everett then read the manslaughter instruction on negligence, emphasizing that everyone has a duty to act responsibly toward others. He clarified that Donna cannot be guilty of manslaughter based on mere negligence and with excusable or justifiable homicide removed. The instruction remains narrow. Both sides had no objections. For manslaughter by act, Everett will instruct the jury that the state does not need to prove intent to kill, only that Donna intentionally committed an act that was more than mere negligence and that it caused death. References to justifiable or excusable homicide were removed. The definition of culpable negligence will still be given, but other references throughout instructions are removed. Instruction 3.5a on principles remains standard. Italicized portions regarding attempted homicide are removed. The instruction tracks first-degree premeditated murder, and the state must prove Donna intended Danielle Markel's killing for that charge. Second-degree murder instructions remain, noting intent to kill is not required. The defense flagged manslaughter intent wording for additional review. Everett confirmed that no firearm enhancement applies, removing language about higher degrees of crime involving a weapon, as there was no evidence Donna possessed one. Judge Everett then reviewed the principal's instruction 3.5b, which tells the jury that if Donna paid or promised to pay someone else to commit a crime, she is treated as if she did it herself. And elements 3 through 1 are included, with the third element simplified to the crime was committed. The state asked whether the other person should be named, but Everett sided with keeping it generic, leaving it to the jury to determine who carried out the act and whether payment was involved. The defense confirmed it wanted the current 3.5a instruction rather than the 2014 version. For count 2, conspiracy to commit first-degree murder, the state must prove two things: that Donna Adelson intended to murder, to occur, and that she agreed, conspired, combined, or confederated with another person, specifically Charles Adelson, Kevin McBanois, or others to carry out the crime. No particular words or overt acts are required, and the defense did not request any instruction on withdrawal. For count 3, solicitation to commit murder, the jury will hear that Donna solicited Charles Adelson, Catherine McBanois, or others to commit first-degree murder and agreed, conspired, combined, or confederated with them to carry it out. Again, no words or overt acts are required, and there is no withdrawal instructions. In addition, for solicitation specifically, the jury is instructed that Donna commanded, encouraged, hired, or requested others to commit the crime. She was not required to take any further acts herself. An affirmative defense is omitted because there is no evidence to support it. The verdict forms for count 1 provide 4 options: first-degree murder, second-degree murder, manslaughter, and not guilty. The defense requested that not guilty be listed first and in lowercase, but the court kept the guilty options first and in bold, all caps, for clarity. Count 2 and count 3 have each 2 options: guilty or not guilty. Each side will have 2 hours for closing arguments. 2 hours each side, with the state splitting its time between opening and rebuttal. The jury will receive photos, discs, jump drives, and written reports, but demonstrative exhibits will not go back with them. And remain throughout the instructions for names and capitalization. The manslaughter instruction clarifies that the state does not need to prove Donna intended Markel's death. Standard jury discharge instructions were confirmed with no objections. Well, that was it for today. And I will be back tomorrow to bring you what happens during closing arguments. And then we will officially be
Here we
on
go, day
verdict
9.
watch.
So what happens if you're ordered to take a drug test, or you take a drug test voluntarily and you test positive for THC, but you know...
We're back with day 9 of the Donna Adelson trial. The woman accused of masterminding the plot to murder her ex-son-in-law, Dan Markel. And I realize that most of you know what happened on this day. It was only the biggest day of trial. So much happened that when I went to record, I had to scratch my original prep because the news kept coming. And then I'm a crime con, so we're late. But we have it all, and by all, I mean it all went down on September 4th, and we're going to finally talk about everything that happened. But before we do, let's quickly go back to the day before, Wednesday, also known as trial day 8, because that day was packed with explosive cross-examinations and decisions that could shape how the jury ultimately views Donna. The defense officially rested its case, but not before one of the biggest questions of the trial had to be answered. Would Donna testify in her own defense? At the defense table, there was a lot of back and forth. Judge Everett allowed a few extra minutes, but he was quick to point out that the defense has had more than enough opportunities to make this decision. Donna hesitated, saying she didn't feel ready to make a choice that would affect the rest of her life. But Everett pressed her forward, at one point even threatening the defense with contempt if she refused to decide. Now, that moment
I'll be right
stood out
back.
to me because Judge Everett is typically a steady presence in the courtroom. He's known for being calm, measured, and almost monotone, yet commanding enough to maintain control without raising his voice. He's fair but firm, and when his tone shifts even slightly, everyone takes notice. It almost seemed like Donna was delaying just to hang onto one of the few things she still had control over. We all know Donna loves control, and this was it. But ultimately, she declined to testify. For many people, including myself, that was disappointing. It would have been fascinating to hear her try to explain away all of the bad facts that the state has laid out, right? Bad facts, in quotes. And while I'll always say that everyone is entitled to a strong defense, Donna's attorneys, Josh Zellman and Jackie Fulford, were definitely working with tough material. Some spectators believe they managed well during the state's presentation, but when it came time to put on their own case, I felt as if they dropped the ball. And here are a few reasons why. First, out of all the witnesses the defense brought forward, attorneys, private investigators, Donna's friends, it's hard to point to even one that truly helped their case. For starters, a lot of you noticed that Donna and Harvey's friends came across as unrelatable, even pretentious. Instead of humanizing Donna, which I think was absolutely the entire point of them testifying, they painted a picture of a wealthy couple wrapped up in gourmet clubs, lavish vacations, and multiple real estate properties. I don't think it did much to humble her in the eyes of the jury. Then there were the private investigators who testified that neither Patricia Bird nor Karina Bernhardt mentioned Donna bribing them to lie. These are the jailhouse snitches. But that doesn't really carry much weight when the physical evidence suggests otherwise. What's even more interesting is that the state actually chose not to show the footage of Donna and Drina sitting together in jail. It was the defense that introduced that video, trying to show the two writing and talking. But instead of helping, it played straight into the state's narrative that Donna had written the script for Drina to memorize. And on top of that, showing Donna cozying up with two career criminals didn't exactly up her image. Patricia and Drina may not be the most trustworthy on their own, but the problem is their story lines up with the script that handwriting analysis confirmed was Donna's. If we've learned anything from cases like James Craig, it's this. Innocent people usually don't conspire with jailhouse informants, draft them scripts, or offer them bribes to lie. If Donna had never put pen to paper, the state's snitch witnesses might have been easier to discredit. But with that script in play, their testimony carries a lot more weight.
You can hop up in my car. You know who you are. I got friends that wanna party and they look like superstars.
That script in play, their testimony carries a lot more weight. The two family law attorneys who testified turned out to be an absolute disaster for the defense. When the defense puts witnesses on the stand, they need them to be at least somewhat likable. But these two came across the opposite. Instead of helping Donna, they mainly tried to throw Dan under the bus for things he did during the divorce, while at the same time insisting the divorce wasn't contentious. That's a tough sell because anyone watching can clearly see it was contentious and emotionally charged, even if from a family law attorney's perspective, it looked routine. Georgia Kappelman absolutely lit up the second attorney on cross, and that exchange might have been what ultimately scared Donna out of testifying. Up until then, she still hadn't committed to a decision, and Judge Everett had reminded her that taking a stand would expose her to cross-examination. After seeing Kappelman in action, Donna and her defense team were probably terrified that she'd be eviscerated if she tried to defend herself. In the end, none of the defense witnesses did anything, in my opinion, to humanize Donna or make her more sympathetic to the jury, other than maybe her former attorney or Wendy's victim advocate. Sometimes when the facts are stacked against you, the best move a defendant can make is to get up there and tell their own story. What happened? That personal connection can be sometimes, in my opinion, the only chance to actually attempt to spark empathy with the jury. And while jurors are instructed not to hold it against the defendant when they choose to remain silent, most people can't help but wonder, if you didn't do it, why not get up there and say so? Why not try to clear your name? And I realize a lot of people say, well, every attorney might say, don't do it.
But in my opinion, what did she have to lose? When it comes to both Zellman and Fulford, I do think they've done the best they could under the circumstances. But again, a lot of you even feel their presentation style might actually be off-putting to the jury. Okay, so here's an example. Jackie repeatedly referred to Dan as Danny, almost as if to show that the defense sympathizes with him. But at the end of the day, the defense's job isn't to get the jury to sympathize with the victim, it's to build empathy for Donna. I mentioned something on Jackie the other day, but here's another interesting fact. She's actually the co-owner of a funeral home where she serves as a Celebrations of Life coordinator. Her role is to help families honor the unique personality and passions of their loved one who has passed away. If you've ever been to a funeral, you know how the eulogies usually go. Everything is framed in the most positive light. Someone who is overbearing, meddling, and controlling life might be described instead as deeply caring, passionate, always involved. That's the kind of reframing Jackie is skilled at. So again, it just makes me wonder if she'll try to use that same technique during her closing. We'll find out in this episode. Maybe she'll attempt to spin Donna's control over her children's life as the actions of the devoted, loving mother who went above and beyond. Well, we're gonna see here in this episode if that's the approach she takes. Here we go. A quick word from our sponsor. I am a big believer in working smarter, not harder, and OneSkin is skincare that actually works smarter, not harder. At the core of every product is their OS01 peptide. That's OS1, the first ingredient proven to target senescent cells, which are basically the aging cells that cause wrinkles and that loss of firmness we all experience as we age. So what has impressed me the most? It's backed by real science. Five published clinical studies, and I noticed the results myself. My skin looks healthier, it feels stronger, and that makes me more confident and ready to take on the day and appear on camera. And it only takes one quick step. You cleanse, you apply, you're done. OneSkin is the world's first skin longevity company, helping your skin act younger for longer. And for a limited time, you can try it for 15% off with my code HIDDEN at oneskin.co. That's 15% off at oneskin.co with code HIDDEN. Be sure to tell them you heard it here. Smart science, real results. Try OneSkin today. Your future self will thank you. So, back to Thursday, day 9. Before closing arguments officially began, Judge Everett went back over the final jury instructions to make sure everything was clear. The verdict form will give them 3 options. Count 1, guilty or not guilty of first-degree murder. Count 2, guilty or not guilty of conspiracy to commit murder, first-degree murder. And count 3, guilty or not guilty of solicitation to commit first-degree murder. After that, the jury was brought in and prosecutor Georgia Kappelman began the state's closing argument. She started by showing the jury a photo of Dan, a father, a son, a brother, a professor, and the victim in this case, a devoted dad who fought to keep his children only to be murdered in a conspiracy designed to silence him. Kappelman told the jurors that the defense's experts had tried to paint the divorce as not contentious. But for Dan, for Wendy, and for Donna Adelson, it was everything. Dan had gone to Harvard. He was a professor. And when it came to this fight, he made it as hard as possible because it was about his children. He reminded the jury that over the past 11 years, every defendant has tried to shift the blame. Sigfredo pointed to Charlie. Catherine claimed ignorance. Charlie insisted Sigfredo, Luis, and Catherine acted alone. Each tried to play the victim, but the evidence caught them all. And now, Kappelman said, quote, "Today is Donna Adelson's turn." Kappelman then outlined the 2 early leads investigators had: the Prius, seen fleeing the crime scene, and motive. And within just 1 hour of the murder, detectives already had their eyes on Donna after Wendy told officers her parents disliked Dan the most. She reminded jurors that in order to convict, the state only had to prove beyond a reasonable doubt that Donna was one of the people behind this crime. Everyone agrees this was first-degree murder. The only question left is who was involved. Kappelman argued that the motive itself is compelling proof. Charlie didn't care about the relocation fight. He didn't care about the divorce battles. What he cared about was the number 1 woman in his life, his mother.
Donna micromanaged her children's lives, and Charlie's role was to solve her problems. And in 2014, the biggest problem was Dan Markel. Appleman reminded the jury that in 2012, Donna helped Wendy secretly rent a new place under her maiden name, timing the separation news to hit Dan just as he was about to give an on-stage lecture. Rob Adelson testified that Donna gleefully reported how they had dropped the news. In an October 2012 email, Donna referred to Wendy as a, quote, hostage in Tallahassee. She pushed for 100% custody, relocation, and even hinted at using a Catholic baptism as leverage against Dan. Donna's plan was clear. If Dan blocked relocation, she would push to wear him down until he surrendered. Wendy herself admitted her mother was serious. Emails also showed Donna telling friends she was at Wendy's kitchen table working on filings. By March 2013, Donna was sending point-by-point responses to Dan's opposition, calling his religious practices fanatical and dangerous, and labeling him psychologically unfit for custody. Appleman said, quote, so much for the claim that Donna wasn't involved in Wendy's divorce, end quote. He reminded the jury that the defense had painted Dan as an intelligent, accomplished father in their opening statement, but Donna's emails revealed how much she portrayed him as a self-important idiot, unfit to parent. This shift shows Donna's direct hand in vilifying him. When Dan chastised Wendy in March 2013 for violating their Skype agreement, Wendy forwarded the email straight to Donna, who dissected it line by line and suggested ways Wendy could recognize his words against him in court. Appleman highlighted her fury, quoting her words, quote, never, never give up. Show this fucker what will make him absolutely miserable, end quote. Evidence shows Donna pushed Wendy to put on the performance of her life. She floated ideas that ranged from $1 million payout to baptizing the grandchildren to even dressing them in Hitler youth uniforms. Tactics, Appleman says, reveal her ends justify the means mindset. Appleman closed that segment by telling jurors, quote, if Dan had let her relocate, he'd be alive. If he moved south, he'd be alive, but he would not submit. Donna couldn't win through court, so she made it Charlie's problem.
This is your chance to prove you've got what it takes. Purdue Global is here to support you every step of the way, so you can focus on what's next for your career, yourself, and your family. Start your comeback today at PurdueGlobal.edu.
It's a problem. In July 2013, Donna emailed Charlie to catch him up on Wendy's case, including bribe discussions. Appleman stressed that pattern. Donna forwarding updates and priming Charlie as the family's problem solver. On one key day in October 2013, Wendy filed a motion to enforce the marital settlement. That same day, she backed out of buying a Tallahassee home after Charlie persuaded her otherwise. Donna called him a miracle worker. And that same day, Charlie raised the idea of hiring someone to harm Dan with Catherine McBanois. In December 2013, Dan emailed Wendy and the parenting coordinator saying the boys told him, quote, Grandma says you're stupid, because he was taking her sunshines away. Dan warned he might seek court relief barring Donna from contact, and Wendy forwarded the email to Donna. And Donna's only reply was, quote, wow. Appleman reminded the jury that bad blood ran long after the 2013 divorce. By early 2014, Donna was calling Dan a bastard in text, urging Wendy to aggravate him with legal filings. In March 2014, she vented about Dan showing up at soccer practice, calling him such a fucker. This proved that tensions never eased despite the defense's claims of an amicable divorce. On March 4, 2014, Donna texted Charlie from a bathroom, urging him to delete the message after reading that she wrote about Dad's birthday gift. Appleman framed that gift not as a surprise present, but as the planned murder. On March 21st, 2014, Donna signed a lease on a Miami condo. After Dan's murder, Wendy and the boys moved in. Kappelman argued the timing was no coincidence, that Donna had secured housing months before relocation suddenly became possible. On March 26, 2014, Dan filed a motion accusing Donna of disparaging him to the children. Again, citing repeated "Grandma says you're stupid" comments. He asked the court to bar her from unsupervised contact. Kappelman told the jurors Donna's grip on her sunshines was slipping. She argued that Donna had seen that the relocation was denied, her bribery attempts failed, and now faced legal filings, targeting her directly. With the court closing off every avenue, Kappelman told the jury, quote, "There was still another option, the hitman," end quote. Between June and July 2014, Charlie repeatedly called Catherine out about, quote, "getting it done," often stepping out mid-discussion to phone Donna. Kappelman argued the urgency reflected efforts to relieve Donna's stress. On July 3rd, 2014, her Evite for Harvey's party listed Wendy's children as Adelson, not Markel. Investigators said that Donna sent the invitations. And on July 6, 2014, from Wendy's phone at Donna's condo, Dan was asked if he would be in town July 14th through 18th. Kappelman highlighted that those exact dates coincided with the hitman's planned trip to Tallahassee. Jeff Lacasse testified on July 13th that Wendy said relocation wasn't possible unless something happens to Dan, and added that Charlie had looked into hiring a hitman. Next, Kappelman went over the timeline of the murder. July 15th, Prius rented. July 16th, Sigfredo and Louise drive to Tallahassee. July 17th, hitman trailed Dan around town. July 18th, 10:45 a.m., shots fired in Dan's driveway. July 18th, 8:11 a.m., Donna texted Wendy about TV set in the living room being fixed, later used as a code on wiretaps. Kappelman says this was part of the cover story. July 18th, 12:45 p.m., Wendy drives past the crime scene, turns around and goes to buy bourbon. She later tells police her parents had more reason to dislike Dan than anyone. July 18th, evening, Donna and Harvey drive to Charlie's at 8:59 p.m. Donna texts, "outside your house." By 10 p.m., Catherine arrives, greeted by Charlie with a gun. The next morning, money is placed in Catherine's trunk. July 19th, after Donna and Harvey visit Charlie, Catherine meets Sigfredo and Louise. Kappelman says the $100,000 payout was split 3 ways, with Catherine's share later deposited despite no formal employment. July 20th, Donna and Harvey drive Wendy and the boys back to South Florida just 2 days after Dan's murder. On September 17th, 2014, Donna signed the first of 44 checks to Meg Benoit, linking family funds directly to the murder for hire. Kappelman argued that if she were uninvolved, there would have been no reason for her to be the signer. Rob Adelson testified that his mother showed a total lack of curiosity about who killed Dan. When asked what she thought happened, Donna allegedly replied, quote, "I don't know and I don't care." On April 19th, 2016, an undercover officer handed Donna a piece of paper. Instead of calling the police, she led her grandchildren past the same spot after picking them up from school. Later on a wiretap, Charlie asked if it involves him or other people, and Donna replied, quote, "probably both of us." After meeting his mother at a marina, Charlie headed to Dolce Vita to confer with Catherine. Wiretaps captured him making incriminating statements inconsistent with his later defense. Kappelman attacked Charlie's extortion defense, noting he claimed Catherine extorted him and funneled payments to the hitman. But Kappelman pointed out the contradictions, that Charlie had let Catherine sleep over, spend nights with her, and even discuss daily plans, behavior unlikely if she were truly an extortionist. Kappelman argued that Donna later embraced Charlie's version as the truth. By law, this can be treated as an adoptive admission, tying her to his story. Kappelman said, quote, "innocent victims of extortion don't stay silent for years, speak in code, launder cash, or sign 44 checks. Real victims go to police." Well, then, Kappelman told the jury that Charlie's extortion story wasn't even created until 2023. Before that, he called the Dolce Vita meeting blackmail. Donna later Googled blackmail versus extortion in October 2023, days before Charlie's trial. That woman said Donna doubled down on Charlie's defense. She hand wrote a script for Drina Bernhardt to testify, even underlining the word extort. The script matched Charlie's invented story, suggesting Donna tried to recruit false memory. In November 2023, Donna texted Wendy saying she didn't know about the supposed extortion. Kappelman argued that if the story were true, why let Wendy and the kids live unprotected in Miami, near the alleged extortionists? In that same text, Donna wrote, quote, "You know I'm next. If that won't happen, I'll take care of that," end quote, which showed her state of mind leading to her planned flight to Vietnam. Evidence showed that after Charlie's conviction in November of 2023, Donna booked a one-way ticket to Vietnam via Dubai. She Googled extradition treaties and applied for an emergency fast-track visa. Her planner contained notes about canceling insurance and prepaying child support 2 years out. Kappelman told jurors this was a conspiracy built like train cars, with each conspirator shielding the others. But Donna left direct evidence: 44 signed checks, license plate notes in her planner, code words like TV on her own admissions. Kappelman closed by saying, quote, "Don't let the way she thought she'd get away with this be the way she does. Find her guilty." Get the pussy covered up. After this, the court took a break before it was the defense's turn to their closing arguments. Fulford began by telling the jury that over the course of the trial, they had heard a lot, and she wanted to clarify some points the state referenced from her opening statement. The state claimed that during her opening, she had praised Dan and then called witnesses to attack him during trial. Fulford said, in fact, she argued the defense part of the trial that actually elicited evidence about Dan's good qualities, including on cross-examination of his ex-wife Wendy. She explained that the two defense witnesses who discussed the divorce were not there to attack Dan. The state had put divorce documents into evidence, including everything Dan had filed, so the defense had to address them. Fulford reminded the jury that their obligation was to defend Donna, and whether the divorce was contentious was a point the state introduced into the trial. The state called it a bitter custody battle lasting years, but the defense said that the characterization was inaccurate. Fulford emphasized there was never a bitter custody battle, and neither Dan nor Wendy tried to take the children away from one another. The case was only about relocation and not a custody battle. She told the jury that Wendy and Dan filed very typical pleadings and the divorce was a standard one, nothing like the drama the state portrayed. Take a listen.
The state is ignoring the evidence that came in through their witnesses that support our defense, and instead they stand before you with calls and text messages and they tell you what they mean. That's not evidence. Their argument about what a conversation means is not evidence. You decide what it means. You've got it in front of you, and you have to consider it in the context of all of the evidence that's presented. Not just what the state puts in, but what the defense puts in. And I know at some point when we were putting on evidence, you all were looking probably at me like, what are you doing? Who cares? Some of those little things matter, and I'm going to cover those in the defense, and you'll see why we put those things in that didn't seem like that had a hoot to do with anything, because they actually did.
Next, Fulford moved on to how the state explained breaking the case of who killed Dan. She noted that Luis Rivera decided to cooperate with the state of Florida in exchange for a deal, adding only 7 more years to an unrelated sentence. But Luis was the man who got in the car, got the gun off the street, drove to Tallahassee, stalked Dan with his children in the car, watched him drop the kids off at school, followed him to the gym, and sat and wait. After that, Dan drove home, unknowingly followed by the men. Luis pulled up behind him in his driveway. Sigfredo got out, shot Dan twice in the head, and they fled back to Miami. Fulford stressed, those are the men who killed Dan Markel, not Donna. She argued that the state has all kinds of theories about how Donna might
have been involved because she said bad things about him. But what did Luis Rivera say under oath? He testified, and I quote, Catherine is the one who elicited Sigfredo to kill Dan Markel, end quote. Catherine later claimed she didn't know Luis was involved. Fulford pointed out that Catherine has lied countless times, adding more to her story each time she testifies. Phone records presented by the state showed Catherine talking to Luis. When Luis and Sigfredo were on their way to Tallahassee and Sigfredo didn't answer his phone, Catherine called Luis. Fulford argued this shows she must have known he was involved. She said, quote, that woman doesn't know how to tell the truth. Luis also testified that Wendy was the one who wanted to get her kids back, which is why the crime was committed for Wendy. Charlie was the one with Catherine who helped set it up. Luis never said Donna was involved. He specifically said Donna and Harvey were not involved. Fulford reminded the jury that Luis was a state witness, meaning the prosecution wants them to believe he is telling the truth. And if that's the case, he's also telling the truth that Donna was not involved. Fulford then turned to the state's focus on relocation. The prosecution hammered the point that relocation was the whole reason they believed Donna had Dan killed. But Fulford pointed out that Dan was killed on July 18th, 2014, and the relocation issue had been resolved over a year earlier. She says the state never submitted any emails or any proof showing Donna continued harping on relocation after the divorce was finalized. Next, Fulford pointed out that Charlie and Wendy weren't always honest with Donna. Throughout the time Wendy claimed she wanted to relocate, she was secretly emailing her life coach that she had made peace with staying in Tallahassee, that it would be best for the boys, and that she also liked her job because it gave her flexibility. Yet, she continued telling Donna that she wanted to move, leading Donna to believe they needed to fight for relocation. Wendy also constantly vented to Donna about things Dad was doing and how horrible he was, naturally riling Donna up as her mother. Take a listen.
Do men or women have an advantage in family court? When it comes to custody,
and how horrible he was, naturally riling Donna up as her mother. Take a listen.
Well, she's venting to her mother about what she claims Danny Markel is doing, and she's venting to her mother about what she wants to accomplish, only she's not being honest with her. On the backside, she's making other plans. It'd have been nice for my client, Donna Adelson, to know that, because these emails that have been submitted here, which are proof that she wanted to have Danny Markel killed, would not have been written. And when she goes to her hearing on the relocation in June of 2013, she has her mother stay outside. Her mother can't hear what's going on in the hearing. She admitted she had several witnesses to call beyond the two that got on the stand, and that after the judge made the comment, she gave up. She could have continued with the hearing and put her witnesses on. The judge could have ruled against her, and then maybe she has an appellate issue. She gave up because she didn't want it anymore, but she didn't tell her mother that. When she told her mother, well, this is how the judges ruled, the mother understood that through the court system it was done, but not with her daughter, Wendy. Because you can continue to negotiate all the way through a final judgment. And that's what those emails say. They do suggest some crazy stuff. They do. But she puts in there, we're trying to negotiate. We're trying to negotiate. Get this, you can still work on this. She doesn't know when she's writing those crazy emails that there's no reason to write them because her daughter agreed. You know, you can have a dismissal on an issue. You can have a denial on an issue. She agreed to it with prejudice, which means it is over. She already made an agreement. She's not going to seek relocation anymore. So my client is hanging out there trying to support her daughter, and now she's sitting in a court of law charged with murder because of what she wrote in emails. Because the truth is, you are here to judge my client based on her conduct leading up to and to the time of death of Danny Markel. That's her conduct. Can you consider things she said and did after to see if it corroborates that she was involved? You can. But her conduct leading up to the day that Danny was murdered is in this book that the state has entered with emails it's separated between where you can see it where they lead up to the divorce and then after the divorce until the time of the homicide. Now, my client did say ugly things about Danny Markell. During the divorce, she did.
Next, Fulford addressed all the names the state highlighted that Donna called Dan, which they used to argue that she hated him. She noted that Donna called Dan names like gibbers, which Wendy said she came up with, as well as a religious zealot, a royal jackass, a piece of shit, a fucker, crazy, a bastard, and Elvis. And in Fulford's opinion,
That's just
the state
horrible.
believes that these insults prove Donna wanted Dan killed. But she argued there isn't a single piece of evidence showing Donna ever said she wanted Dan dead, that she planned to hire someone to kill him, paid him, or celebrated his death. All the state has is name calling. Fulford said the prosecution spins this evidence to make
Name
Donna
call
look
don't
bad,
mean nothing.
but it's not proof she orchestrated his murder. She then moved on to the grandmother motion, which the state argued pushed Donna over the edge. Fulford pointed out that the state's own witnesses said Donna didn't know about the motion. Wendy testified that Donna never saw it or discussed it, and even if she had, the motion only alleged that the 3- and 4-year-old said Donna called Dan stupid. The state claimed that was enough to drive her to solicit murder, but Fulford called that spin unbelievable. Listen to this.
That's their spin that they want to put on it. Because they've got this theory that she's the mastermind. And then they stand up here in their closing and they say, everybody has been charged in this case, so they want to point at the other one, point at the other one, and point at the other one. No, 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 no. Who is pointing at these people? The state of Florida. The state of Florida is doing the pointing. They're the ones getting the warrants. They're the ones doing the investigation. They're the ones charging people, deciding who they're going to give deals to and not. That's them pointing the finger. That's not my client. There's no evidence of that. They bring the charges, they prosecute, they get the convictions, they get people sent off to prison. Not us. What? We're pointing the blame at the killers for killing them? They proved that those are the people who killed them. That's not us pointing the finger. They actually did it and it's been proven. And we're distancing ourselves from Charlie Adelson? Let me tell you something. They elicited the testimony about Charlie Adelson over our objection, if you happen to remember that. It came in. Charlie Adelson is not on trial. You may be sitting in that jury room thinking, well, Charlie did it, and it sure looks like Wendy did it. That doesn't have an ounce to do with Donna Adelson doing a thing. Not a single thing. If you think he did it, he's been convicted. He admitted in his testimony that he is the person, although he claims he was extorted, he is the person that took $138,000 out of his refrigerator-size safe that he has at his house, with the money exactly like he says he kept it, stapling $100 bills together in stacks of 1,000, staple, 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 staple. He
Come on.
staple. He said he took that money out of his safe and he gave it to Catherine McBanois that night. Whether that's his girlfriend and they're still fooling around on the side, that's between the two of them. That's got nothing to do with my client. He did it. But now they want to say Donna Adelson did it. Pick one. You don't like our theory? That's what they say. You don't like our theory? Oh, well, you like our theory on everybody else. Pick one. If you have prosecuted Charlie Adelson for paying the $138,000 staple, just like their other witnesses in this case said, why are they now saying Donna Adelson provided the money? Oh, wait. Oh, because Catherine McBanois, who's been sentenced to life and is telling her 6th story now, has decided she'd like to see her kid someday. So now she's going to come in and provide information that will help the state prosecute an innocent woman so she can go home to her children. That's what that's about. So she claims that this all goes down. Charlie puts the money, Charlie, not Donna, Charlie puts the money stapled just like she knows he does into her trunk. She drives it the next day to Sigfredo Garcia, her baby daddy. He takes it out of the trunk, and a day or two later, she gets hers back. And she says he puts it in her closet, and to this this day, she wants you to believe that that money sat in her closet and she spent it along the way. The records that Miss Hole testified to, showing all her cash deposits, she clearly was doing something with it, right? But to this day, she wants you to believe she has absolutely no idea how much money she had. Never counted it. Really? She must think y'all was born yesterday. But here's something. She's got this new thing she wants to testify to. That the money was wet, and Charlie told her that Donna had washed it. Her money's wet, that she hasn't touched, that's been somewhere else for these number of days. Well, what did Louis Rivera testify to about his money that he got? He said it was weird. Well, how was it weird? Well, it was stapled in $100 bills, stacks of 1,000. Not a single word about wet, and he got his money before she did. He got it straight from Sigfredo. This washing money wet thing is nonsense.
Fulford then addressed Catherine's testimony that every time she spoke to Charlie about, quote, needing to get the job done, he would step out of the room and say he was talking to his mother. Fulford pointed out that Catherine never said when these calls took place, never actually overheard them, and noted that Charlie was seeing multiple women at the time. He could have been talking to one of them and simply told Catherine it was his mom. Fulford argued that Catherine was motivated to share this new information because she wanted to get out of prison, not because it was true. Fulford also addressed that the claim that the birthday present was code for Dan's murder. While Rob said there would be no birthday present, the gift ended up being a special chef hired to cook. Fulford noted that during cross-examination of Rob, the jury learned he rarely spoke to or saw his family, yet the state wanted them to believe everything he said about Donna. She emphasized that Rob had an axe to grind, was not involved in day-to-day events, and had no first-hand knowledge, but the prosecution relied on his testimony to implicate his mother. Next, Fulford showed parts of emails between Donna and Wendy that the state left out. While the prosecution highlighted Donna helping Wendy with divorce documents, they omitted that Donna advised Wendy to make Dan pay for child support, schooling, sports, and other expenses. Fulford asked, if Donna wanted Dan dead, why would she be helping Wendy plan for him to financially support the boys? Why advise on negotiation terms if Dan was going to be dead anyway? She also addressed the so-called $1 million bribe the state discussed. Fulford explained it was intended so Dan could relocate too, allowing him to commute 2 days a week to teach while living in Miami and co-parenting with Wendy. They would cover plane tickets and help him buy a house. Fulford asked the jury, why offer all of this if they were planning to have him killed? Fulford also ridiculed the state's alibi theory. Harvey, not Donna, arranged the Geek Squad repair for the broken TV, even checking a box to allow for an earlier appointment if one became available. Fulford said, quote, who does that if you've scheduled a murder? It makes no sense. They also played a recording of Wendy calling Donna from the Tallahassee Police Department after the shooting. Donna's voice was audibly shaken, asking, how did it happen? Where is he now? Fulford said, quote, this is not someone who planned his death. She was shocked. Finally, Fulford emphasized that Donna's phone never pinged near Charlie's the night of the murder. She said that the state wants the jury to believe she dropped money at his house, but they can't even put her phone in the same tower zone. Fulford pointed out that Patricia Bird and Drina Bernhardt each claimed Donna offered benefits for false testimony. She said, quote, 2 felons, same cell block, same script, neither ever on a witness list. They want deals, not truth. Deals, not truth, end quote. Fulford emphasized that Donna only learned the details 2 months after Dan's murder from Charlie, who told her he was being extorted and needed checks written to Catherine. She believed her son's life was at stake, so Donna wrote payroll checks at Charlie's instructions. In April 2016, after agents staged the bump, Fulford noted that wiretaps were approved only for Charlie and Catherine, not Donna. She asked, quote, if she was the mastermind, why wasn't her phone tapped? Next,
she addressed Harvey and Donna's visas, which the state entered into evidence. The visas said good for single or multiple entries, and a visa for tourism, not residence, can come and go as you please. Wilford noted that during Charlie's trial, Donna was very depressed and making remarks about self-harm, and Harvey wanted to get her away on a trip to clear her head. She also highlighted that if Donna and Harvey were really trying to flee, why did they only bring one suitcase, one carry-on, and only a few credit cards? It wasn't meant to be a long trip. Fulford then reminded the jury that law enforcement said Donna was immediately a person of interest after Dad was shot in 2014. Yet, after collecting financial records, she wasn't arrested in 2015. After the bump, she wasn't arrested in 2016. She wasn't arrested when all of the co-conspirators were taken into custody, nor in 2017, 2018, 2019, 2020, 21, or 2022. When Donna got her travel visa and booked her tickets, there was still no warrant for her arrest. She wasn't doing anything wrong. It wasn't until she was already at the airport that the state obtained a warrant, and she knew nothing about it. Fulford asked the jury, why would she be trying to flee if she wasn't even aware of a warrant for her arrest? She reminded the jury that the FBI, the FDLE, and the TPD collected hundreds of thousands of emails, over 2,000 calls and texts, bank records, and cell tower data, and still there was nothing tying Donna to the murder. Fulford stressed there was no email, no call, no written record showing Donna plotted Dan Martell's death. She said, quote, "The worst they have is foul language. That's not proof of murder," end quote. Fulford urged the jury not to be swayed by the state's narrative. She ended her closing with a clear directive saying, quote, "You have to find her not guilty. The state has failed on all three counts." Take a listen.
And there's not a single piece of evidence that connects my client to that murder. Charlie Adelson? Yep. Potentially Wendy Adelson? She's the one who said she hated him. She's the one fighting with him in court. Donna Adelson? Nothing. Not a single piece of evidence. You have to find her not guilty because they have failed to do their job on all three counts. They cannot prove she had him killed. At the time that he was killed, she had paid anybody or asked anybody to do it. Please take this case seriously. Please go back and review the evidence. Please discuss what's been presented. Don't get talked into something that you don't agree with. The verdict has to be unanimous. If you don't reach an agreement, if you can't be unanimous, there's another procedure we go through. But please, don't buy into what the state is about to do, telling me how wrong I am, or telling you how wrong I am about everything, and how they have this mountain of evidence, because they admitted it. Agent Sanford admitted it. There is no direct evidence linking Donna to anything. And all this circumstantial evidence isn't really circumstantial evidence. It's argument about what it could mean, what it possibly mean. Could it have been? That's not beyond a reasonable doubt.
Kappelman opened her rebuttal by reminding the jurors that what attorneys say is not evidence. Only the exhibits, testimony, and their own memories matter. She urged them to look at the evidence and decide for themselves what is true. Addressing the defense's claims, Kappelman said that while they argued Donna was framed as fleeing, Donna herself obtained a fast-track visa to a non-extradition country. She made those choices. Kappelman told the jury. The defense also claimed that Wendy never told her mom she had given up wanting to relocate, but Kappelman reminded jurors that Wendy did, in fact, share that information with Donna. Take a listen to this.
Wendy didn't bother to tell her mom she was ready to give up on the relocation.
Yes, she did.
Look in the emails. She was giving up, and Donna wasn't having it. That's when she gets the totally unhinged email from her mother suggesting, "You're not going to give up. You want to move on with a sense of peace? Hell no, we're going to fight this guy. We're going to dress your kids up as Nazis." That's what happened when when Wendy suggested giving up. Never, never, never give up, right?
success is going home and seeing, my kids smiling. Success is opening doors to a business. When we started getting our designs ready and getting more creative with our designs, that's when we went from 10 little waterfall racks to now standalone racks, a whole wall system. We're building out different ways to display shirts. Just having that technology in our hands and being able to put what we envision.
Suggested giving up. Never, never, never give up, right? This murder charge is not based on the fact that she said some bad words. I mean, I'd be facing murder just in this courtroom. Obviously, people. That is not what this case is about. You've got to look at all the evidence. I mean, it is death by 1,000 cuts. It is powdered sugar. You've got to look at the whole thing and make a decision. And I'm sorry that there's not a smoking gun, but she was too smart for that. She thought about it. She planned it. She made sure we could never get her, right? She took precautions, but she did make mistakes, and that's what all those exhibits are. Mistakes.
Kappelman said she isn't trying to spin anything, and the only spin that matters is the jury's. She explained that she tells them what she thinks the evidence shows, the defense tells them what they think it shows, and the jury has to decide for themselves what they believe the evidence shows. She highlighted that the defense seems to think that just because Charlie was convicted, Donna cannot be held responsible. Kappelman made it clear that everyone involved should be held accountable, so perhaps insinuating that Wendy is next, who knows? To close, Georgia brought up two particularly shocking emails from Donna. Take a look.
2 years after the murder, we've got two emails, 64T and 64I. The defense told you in opening that this defendant cares about others more than she cares about herself. The problem is that she decides what other people need, what's necessary for other people in their lives, and she is willing to justify whatever ends she thinks are needed, right? Any means to get to those ends are justified in her mind. The problem is she doesn't care about the collateral damage to get to her ends. The evidence has shown that this defendant, I think, did believe that Wendy and those boys were better off in South Florida. She thought that's what they needed. They would be better off with her. And she was angry that that couldn't happen. Dan Markell is the thing standing in the way. What was the cost of that to not only Dan Markell, but to those little boys? Those little boys lost their father. Look what she says in 64T. Children are 2 and 3. Children do not even have a memory of life before age 5 or 6. Look what she says in 64II when Wendy is concerned. This is 2 years after the murder. Her child is having trouble at school, crying because he misses his father. And this woman, this nice grandmother, innocent woman, says, quote, I still do not believe that Ben is sad about his father. Quotations on the sad. 64II. I still do not believe that Ben is sad about his father. I spend a minimum of 25 hours a week with him, and oftentimes more than that, including weekend times and sleepover days, and have never experienced a time when he was sad. I think it's just another phase of the many, many phases that kids go through. The problem is they have a highly intelligent and sensitive mom. She doesn't believe that this kid is sad because she can't take accountability for her own actions and the catastrophic consequences that this had on everyone's life in her family. Not just her son, not just her daughter, not just Rob, not just Dan Markell, but those boys who lost their father. It wasn't better for them to be in South Florida. It was better for them to have their father. You must not base your verdict on the feelings of sympathy, prejudice, bias. Your verdict must be based on the evidence and the law. Yes, she's a grandmother. Most murderers don't look like that. But the evidence has revealed what she is. Please don't let her appearance influence your verdict in any way. It involves the two of us. What about the script? They didn't even talk about the script. She wrote a script for a witness. It was perjured testimony based on a lie, an extortion lie that's been proven in court to you to be false. This defendant tried to erase Dan Markell, thinking there would be no harm to those little boys. They don't have a memory of their father. They feel the absence of their father. This defendant decided they didn't need their dad. She doesn't get to decide that. She wanted it done. She brought the money. She stroked the check. She didn't have to do that. Charlie was a signator, had signing power on that account. He could have written the checks. She wrote the checks. Why? Because she was neck deep in this thing. She wrote the checks. She said it involved the two of us. She wrote that script. May you have the strength and the common sense to see this evidence for what it is. It's only one thing. There's only one truth. It can't all be right. It's only one truth. Render a verdict that does justice. Find her guilty. Thank you.
Dreaming of the perfect family trip?
Who are you?
Honey, Priceline's AI traveler.
And with that, the decision was in the jury's hands. As for the closings, I think the defense did the best they could with what they had. Fulford made some strong points, highlighting the gaps in the state's case and trying to show that there was no direct evidence linking Donna to the murder. She emphasized the inconsistencies, the timing of events, and how the so-called fleeing was really just a normal trip. But once Kappelman got going, she was a force to be reckoned with. Her rebuttal, in particular, was very strong. And being the last thing the jurors hear before deliberations makes it...
Come on. Come on, you're almost done. Come on, phone. Come on. I'll pull the charger. Let me go out, come back in. Come on. Come on. Don't tell me I'm gonna have to end this. Dang, I only had 20 more minutes to go. Thank y'all for being with me. Like, share, subscribe. Enjoy your evening. Good night. Peace.